Hey guys, I am so excited about this one. I was so excited I talked about it a little bit on X already. Usually I would do the stream and then post the X updates. This is a New Jersey Supreme Court case. So it's Gerald. Sorry if I say Gerard. His last name is Butler. I know I'm going to get that confused at some point during the stream, but it's a state v. Gerald Butler. It's a case where Gerald was convicted of different drug charges. And on appeal, which his appeal failed at the Court of Appeals. He had to take it all the way to the Supreme Court, which has now agreed with the arguments and decided to reverse the conviction and remand it back down to the trial court for a new trial. But he made several arguments. And overall, the Supreme Court agreed that the cumulative effect of the different errors was enough to prejudice the defendant, Gerald, and that he deserved a new trial, that his trial wasn't constitutionally fair. The number one reason I was so excited is, in opening statements, the prosecutor at the trial compared Gerald's case, the charges Gerald was facing, which involved nothing to do with organized crime. She explicitly made a comparison to the show The Wire and said things to the effect of, you know that show The Wire, about the organized crime and all of those things. Kind of giving a framing to the case she's arguing to the jury of a fictional situation that really isn't even comparable. So what's really cool about this case is that introduction, that use of a pop culture reference attracted to Amicus briefings, or amici briefings. So if you want to read these in full, we're going to look at parts of them as we go on with the stream. But if you want to read any of the documents that were involved in this appeal to the state Supreme Court, there is a link to this thing that I'm showing on screen in the description, and every document that is relevant to the Supreme Court appeal. There's always like a view button or a hyperlinked, whatever it is. There's going to be a link you can click and read the full thing, because some of them are like 60 pages long. But I thought it was really cool that the ACLU for New Jersey and ACTL, which is like, we talk about GACTL and FACTL, it's the New Jersey version of the criminal defense lawyer group. They both were like, this is ridiculous. We need to stand up for the defense as friends of the court. And they individually filed briefs. So it caused a lot of commotion in the New Jersey appellate arena. We're going to start with the oral arguments. So obviously we already know the outcome. The appellant here, Gerald Butler, was successful, but it makes sense to me to start with the oral arguments, see what they argued. It's going to be a little bit of a wonky display, but there should be closed captions, and I think we'll be good to go. Before we do that, hey to everybody. Hey to J Money. Good to see you. Thank you for all the love in the chat. We've got Keith checking in from Chicago. Good to see you. Hope you're doing well. Hey, Neb. Hey, EJF. We're collecting the errands early this morning. Hey, Corky. Good to see you. Hey, Danny Not Wahlberg. See Mish is in the building. Gloria's here. Good morning. Good morning. Candace, good to see you. Coco, a lot of C names. A lot of C names in here. And then Danny here for the D's. And then, hey, Jordy. Hey, Jordy. So let's get into these oral arguments. I don't think I've ever watched a New Jersey State Supreme Court oral argument, so these are going to be new faces for me. Hopefully the volume's good, because I don't have a boost here.
State versus Gerald Butler. Can we please have appearances of counsel?
Wilson Gifford, Assistant Deputy Public Defender for Gerald Butler.
Oh, we have a cougher.
Good morning, counsel, and welcome. Ms. Gifford, please. We're going to go till roughly 12:30. I'm not certain we'll finish the argument by then. We'll do our best.
Okay. Good morning, Your Honors, and may it please the court. I'd like to reserve 2 minutes for rebuttal if necessary.
That's fine.
Prosecutors have a duty to obtain convictions based on evidence of the charged offenses. From opening through summation, the prosecutor in Gerald Butler's case violated that duty. I'd like to emphasize what this case was not about. It was not about gangs. It was not about gang violence. and it actually wasn't about any violence whatsoever. Instead, it was about whether Gerald Butler, possessed with intent to distribute contraband found in an apartment, sold drugs on one occasion, and conspired to commit those crimes.
So she just summarized the 3 charges. They found drugs on one occasion. They did charge him with conspiring to sell those drugs. But they're going to compare this guy and the charges he's facing in front of the trial jury to the show The Wire, which is about violence and organized crime and having to bring down this whole scheme. Doesn't really seem like if you go in and find someone's got weed in their college dorm and you want to prosecute them for it, do you think that's comparable to The Wire?
Yet, the prosecutor and testifying officers bombarded the jury with improper commentary and testimony, suggesting that Butler was a violent gang member. Then, in a case that turned primarily on Butler's connection to an apartment, the prosecutor elicited improper testimony about a warrant that bolstered Butler's connection to that apartment. These errors, individually and cumulatively, made it more likely that the jury would convict Butler of the charged crimes and therefore require reversal. I'd like to discuss the trial errors in the order of my brief. I'd like to begin with the prosecutor's comparison of Butler's case to The Wire, then turn to the problematic statements about the investigation, and then discuss the search warrant issues before wrapping up with cumulative error. The prosecutor opened the case against Butler by discussing the television show The Wire, a popular show about violent drug dealing gangs in Baltimore. The prosecutor told the jury that in The Wire, there was a rash of crime happening in Baltimore, that the crime was organized and hierarchical, and that the police ultimately realized that in order to find out how guns and drugs were flowing into the community, they needed to focus on one person through a wiretap. The prosecutor continued, and I'm quoting, "That's similar to this case." The prosecutor explained that there was a rash of violence happening in Millville in 2016, and that in order to figure out its, quote, origin, the police decided to get a wire. The wiretaps ultimately led to Butler's arrest. The prosecutor drew a direct analogy between The Wire and Millville and implied that Butler was at the origin of Millville crime. This was entirely improper. A prosecutor's reliance on The Wire would be inappropriate in any case, as it's not in evidence and the show is filled with gang violence and organized crime, but it was particularly inappropriate here, where Butler was not charged with any gang-related or violent offenses. The prosecutor's use of The Wire created the very real risk that the jury convicted Butler not based on the evidence, but on the belief that he was responsible for some widespread Wire-esque crime in Millville.
Wire-esque?
As in State versus Holmes, where the appellate division found reversible error in the prosecutor's reliance on the war on drugs to obtain a conviction in a simple possession case, the prosecutor's reliance on The Wire, and I'm quoting, was a thinly veiled attempt to inflame the jurors by identifying defendant with matters of public notoriety as to which no evidence was or could have ever been introduced. Bless you. Not long ago, in State versus Williams, this court cautioned prosecutors against implicit or explicit comparisons between the defendant and something the jury associates with violence or guilt. But that's exactly what the prosecutor did here.
So
this court should reiterate that prosecutors must exercise extreme.
I think the case she's referencing is a case where what happened in the Williams case, the prosecution in that trial compared what they were charging the defendant with in that case to the movie The Shining. So, yeah, a pretty popular reference. I mean, I'm sure there's 55 people watching in here right now. I'm sure like 20 of you would understand if someone made a reference to The Shining that they're probably comparing it to some gruesome, creepy type of maniacal murdering of a horror story. So that's what the case she's referencing. As a comparison here, they cited The Shining there in that case.
Extreme caution when making extra evidentiary comparisons and reverse Mr. Butler's convictions. If your honors have no questions about the Wire comparison, I'll move to the commentary. Yes, Your Honor.
I do. What is in the record in terms of what exactly the Wire is about?
It's what the prosecutor said in the very first paragraph.
You're saying that the Wire is a show that exemplifies gang violence, and you're making a statement that what The Wire is about. What exactly is in the record that we can look to say whether that's an accurate characterization of The Wire? And here's why I ask. I mean, I know there's an entire season of The Wire that's devoted to police misconduct. And
He's a
that
fan.
season would presumably inure to the benefit of a defendant. So what are we looking to get from the record to be able to rely upon as to what the association with The Wire means?
So I think it's exactly what the prosecutor said when she introduced the concept of The Wire, that in Baltimore, there was a rash of crime. The police needed to figure out how drugs and guns were flowing into the community. And in order to do that, they needed to focus on one person. So that certainly isn't anything about...
Like, it can't just be me, right? If that's how it's framed in opening by the prosecution at this trial, and I wish there was trial footage that we could just watch the underlying trial and watch these opening statements, but that would anchor me. If that's the first thing I'm hearing before this case kicks off, I'm like, oh, we're prosecuting a kingpin or someone at least like higher up on the chain who's moving a lot of weight and, you know, is willing to commit violence to make sure nobody interferes with his money or the organization that they're a part of.
Police misconduct. It's about, there's like a rash of crime, and in order to get to the bottom of it, the police need to focus on one person.
There's
And now,
nothing else in the record
about the content of The Wire,
of the show.
specifically, no, but it is a extremely popular television show. And I think it's fair to assume that many of the jurors had seen that show and would know that the show was about gang violence. It's about organized crime. It's about drug dealing. There's murder. And the jury from
Police misconduct.
And in part, Your Honor, but I think when the jury is viewed, that's not the way that the prosecutor was invoking it. The prosecutor was invoking it to say there's a rash of crime and the police need to figure out how to get to the bottom of it, and they need to focus on one person. And so I think when the jury is hearing that, they're not thinking about police misconduct. They're thinking about, okay, so as in The Wire, there's a rash of crime in Millville. In order to get to the bottom of it here, there's drugs, there's guns. The police needed to focus, get a wire, focus on one person, and they're looking to Mr. Butler, who is the person on trial before them. So I think...
Yeah, and what's weird to me is when she quotes what the prosecutor said at trial. I don't know the prosecutor's name. I just know it was a woman. I'm not even really paying attention to the wire, the wire, the wire. It's the quote, the wording. Like, it's this rash of violence in Baltimore. To me, that stands out more to me than just naming the show The Wire. I'm hearing those phrase words, the imagery. It's this whole organized thing. It's bigger than just one person. You could kind of swap in any show or any comparison. You could compare it to something that actually happened, and it would make me visualize this thing about the person that's on trial here. And hey, Nana Banana, good to see you. Thanks for being a member for 16 months. Yeah. Martina says, as you've seen in The Godfather, this guy was a criminal just like them. As you've seen in The Problem Child, this kid had some issues. Yeah, it could just be anything. Anything. And that guy Nick is like, oh God, I've never thought about how a prosecutor would watch The Wire.
they're viewing from the very beginning of this case, the invocation of The Wire is tainting all of the evidence through which they're is tainting the ways in which they're viewing the evidence against Mr. Butler. In their mind, they have an image of widespread crime, drugs, guns, and that there's one person who's at the center of all of that.
Didn't the prosecutor, in discussing The Wire, the show, and then moving on to this investigation, indicate and that what was happening, and they finally decided they needed to get a wire? So as they narrowed down their investigation, they narrowed it down to 4 individuals. And then the prosecutor made clear that Mr. Butler wasn't one of those 4 individuals. So it doesn't, from my reading, it doesn't seem as though the prosecution said we had to focus on one person and that was Mr. Butler. It seems like they said the opposite in getting the wire.
They need to focus on, they start by focusing on 4 people, but ultimately those 4 people lead to Mr. Butler, who is the man on trial. So I think that it's a very fair inference for the jury to make that while the investigation didn't start with Mr. Butler, it ended with Mr. Butler. And the fair assumption there is that, oh, okay, so Mr. Butler, they finally figured out who's at the center of Millville crime, and that's the man on trial. That's Mr. Butler, even if the investigation didn't begin with Mr. Butler.
But that's not true. I mean, Mr. Butler is implicated by the wire because of a collateral call from the phone that the law enforcement was up on.
Yes, he was eventually implicated through a wiretap. But I'm not saying he wasn't implicated through a wiretap. The prosecutor said he wasn't the initial target. They first wiretapped 4 people, and that led to Mr. Butler and to a wiretap of Butler. So in response to Justice Pierre-Louis' question, I was just saying that the fact that the investigation initially focused on other people doesn't mean that the assumption for the jury to make was that it was Mr. Butler who was ultimately wiretapped and at the center of Millville crime.
Isn't it possible that to Justice Hoffman's question, that there was one interpretation that you're suggesting that could be what the state was putting forward, but the defense easily could have gotten up in their opening statement and said, you know, we've also seen The Wire, and there is a whole season dedicated to police misconduct, and that's what we're alleging in this case, to sort of diffuse that analogy. This isn't one that's so clear like the Shining example that we have, where that I think nobody would disagree that the violence and what was implicated by that scene in that image can only be seen one way, versus here where there may be other arguments that could be made. How deep into it should we be delving to decide whether or not this is fair or not?
I think what's really important here is just the context in which the prosecutor invoked The Wire. She says there's a rash of crime. They had to get to the root of it by getting on a wire. Like, same thing in Millville. There's a rash of crime, had to get to the root of it by getting on a wire. And so I think both and that in and of itself is just asking the jury to picture Millville as, you know, similar to Baltimore in The Wire, and to picture Mr. Butler at the center of Millville crime. And I think as in The Wire, as in the State versus Williams with the Shining case, you know, obviously The Shining, The Wire, it's not in evidence. It's not fair comment on the evidence, because in both cases, which I'll get into in a bit, but the state's case did suffer from evidentiary holes. And in both cases, the prosecutor is using this extra evidentiary pop culture comparison to fill the holes. I mean, specifically in this case, well, actually, if it's all right, before I get into the harm, I would actually like to talk about the testimony and commentary about the investigation itself, because I think that really, that really built off of the prosecutor's, erroneous comparison of this case to The Wire, because it wasn't just in isolation. It wasn't just one reference to The Wire. Then throughout the entire trial, there's ample testimony.
Oh, this made me laugh out loud. Sheriff Tuck's like, the fact that there were other good people in The Shining doesn't mean people will ignore a comparison to the evil character. Like, yeah, what's the parallel argument here? Is the defense attorney in the Williams, whatever happened in the Williams case, supposed to get up there and be like, contrary to what the prosecution just told you in opening about The Shining, this could be a case about 2 little girls and a hallucination of 2 little girls riding bikes down the hallway. Like, what? How does that dispel the comparison? Like, the whole problem here is I think it's actually worse than The Shining, because I'm assuming in the Williams case, maybe somebody was murdered and it's just like a prejudicial inflammatory image that you're putting forth to the jury. And I have to read the case. I don't know the case, but they're focusing on the imagery, the judges are. So maybe that's the issue. Same reason it'd be prejudicial to show a jury like 50 autopsy photos when you only really need to show a few to get the point across. It just becomes inflammatory. But here, when you're making this comparison to organized crime, and then you end up telling the jury, we're going to hear that, they have people on the stand to talk about this search warrant that was initially looking at other people. And sure, that's how they eventually found, and they're not alleging that Butler was actually like in some organized crime with these other 4 people. He just got like, he bought something off one person, was not part of their organization, whatever. But when you tell the jury this whole thing, and you give them a visual comparison to anchor to an opening, you kind of make it seem like this is why there's problems in our community. And as jurors, if we want to keep our community safe, this is the big bad guy. Like, I get what Allison Gifford is arguing here. And I don't really see it being all that comparable to like a bloody, gory image. I think the issue is you're comparing it to crimes that aren't even charged here.
And commentary about the size, scope, and background of the investigation, that make it seem like Mr. Butler is part of some huge, widespread organized crime, gang violence, gun trafficking, drug trafficking. And again, none of that was supported by the evidence. So I think when you have the prosecutor's use of the wire in opening and then coupled with all of these comments throughout the trial, it made the Mr. Butler seem like he was part of a much larger and more nefarious operation than the evidence would permit.
How do we balance this though? Because there are times where, you know, this is not in evidence, right? These arguments are not evidence. They are trying to build analogies, both attorneys, right? Prosecutor, defenses are trying to build analogies and metaphors to establish their case. Defense attorneys sometimes rely on the lack of CSI evidence, and if you've seen CSI, you know what to expect. And here, you're not going to see, you know, all of these things.
That's not the same. Chat, when we've heard references to CSI in opening statements. We've actually heard it from prosecutors too, where in cases where they don't have a lot of evidence, it doesn't work like you think that we can just figure everything out in some fancy lab. Sometimes we just don't have information. We've heard prosecutors use that. We've heard defense attorneys say, hey, DNA doesn't work like that. What's the issue? You are telling the jury that this is not like CSI. This is not like what you see in these popular culture TV shows. In this case, it's very much like The Wire. It's the opposite. It's embracing the fiction.
What's the limit in terms of the prejudicial take, given Justice Hoffman's position that the show might have ample room for both sides to argue that it's exact opposite of what the state's arguing?
I think the limit is that when it's the comparison, the reference itself is prejudicial and it's used to fill a gap in the state's case, But
isn't it always going to be prejudicial when the state's making it? Right? The state's making the analogy for the purpose of trying to support their evidence against the defendant in that case. It's always going to feel that it's meant to mount its case against the defendant. But prejudicial is something else.
If the prosecutor says, you know, in CSI, there's always DNA evidence, and there's not DNA evidence in this case, that is not necessarily invoking in the jury's mind images of something that could be used to fill a gap, you know, that's comparing the defendant to, you know, a particular person, a particular image of something very prejudicial that's used to fill a gap in the state's case. There was no need for the prosecutor to invoke the wire to introduce the concept of a wiretap. That's a pretty straightforward concept.
It seems like isn't your argument, even if the wire had been used only to educate the jury about what a wiretap is, it seems like it would have been a different case. It seems like here, even if the jury didn't know anything about the TV show The Wire, which again, probably unlikely, but maybe there was a juror who had never heard of it, the prosecutor specifically says, in that show, there was in Baltimore a rash of crime. It seemed very organized. People were always at certain locations. They seem to be following a hierarchy or someone's order. They're trying to figure out guns and drugs and how it's all coming into the community. And they're looking at all these locations. They can't find them. And then eventually they realize that there's one person they need to focus on. That's the only way to find the guns and the drugs and how they're flowing into the community was to get on that person's phone. So they got a wire that's similar to this case. So it's not that the prosecutor is just saying, this is what a wire is. It's when someone taps a phone. The prosecutor is saying there's all these guns and there's all this drugs. And it seems like
that was a quote she was reading from opening statements from the trial prosecutor, by the way. So I think this justice is already on the same page as Allison Gifford.
It's organized and everyone's in different places and it all comes back to one person. And that's like this case. It seems like that is a problem regardless of what else could or could not be found in the TV show itself. No?
I think that's exactly right, Your Honor. And I think it would be unnecessary to, you know, and improper to invoke the wire in any context because it's unnecessary. It's not in evidence. But here, that wasn't just what the prosecutor did. The prosecutor explained what happened in The Wire and then said, that's like this case. I mean, similarly, in the Shining case, the prosecutor held up the image of Jack Nicholson as he's, using an axe to cut through a door to say,
oh, man,
actions speak louder than words. It's getting into the details of what happened in that case and asking the jury to extrapolate and pull comparisons from that reference to the evidence before the jury. So I'm not taking the position that any reference to any, pop culture, anything extra evidentiary is always going to require reversal. I think most of the time it's probably unnecessary. But whether it amounts to reversible error, I think it's important to look at, the context of the comparison, how unrelated it is to the evidence, and the details, obviously, of the comparison, and whether it's used to really fill a gap in the state's case.
Unless I misunderstand, it goes right to the, Justice Van Reppen's point. They did not go up on Butler's phone, right? They caught Butler on a collateral call. They weren't up on Butler's phone, right?
Originally, but then they wiretapped Butler after that. After they originally, they were wiretapping another person. That person reached out to a number that they thought was Mr. Butler's, and they wiretapped Mr. Butler's phone. And then, the bulk of the evidence was against Mr. Butler was wiretapped evidence. So the wiretap was, it was an essential part of the case against Mr. Butler. And I think the jury could have, certainly concluded that, as a wiretap in the wire was necessary to get to the center, the person responsible, that was here, Mr. Butler. And, as I alluded to before, the prejudicial nature of the wire comparison was really just emphasized over and over again throughout the case, because the officers testified about the background, size, and scope of the investigation in a manner that made it seem like Butler was involved in, violent gang-related crime. And so, first, over defense counsel's objection, 5 officers testified that they worked for the Organized Crime Bureau, and the lead officer testified that the investigation leading to Butler's arrest was a large-scale weapons trafficking and narcotics investigation that targeted violence in the city of Millville, as well as weapons trafficking throughout the country. That officer also testified that the investigation began in response to several shootings in Millville. All of this testimony fails Rule 403's basic relevance test. Neither the name of the unit investigating Butler nor the scope of the investigation made it more likely that Butler committed the charged crimes. Instead, these details just encouraged the jury to prejudicially speculate that Butler was involved in a large and violent operation. The prejudicial nature of the officer's testimony was exacerbated by the prosecutor's improper statements in opening and summation. As we discussed in opening, the prosecutor said that the investigation began in response to a rash of violence. And in summation, the prosecutor told the jury that the case involved a huge, wide-scale operation, which was about gun violence in the city of Millville. Again, Butler wasn't charged with any gun violence or any violence at all. And as with the wire comparison, all of these statements implied that the state had knowledge of Butler's criminal involvement beyond what was presented at trial, and encouraged the jury to convict based on that criminal involvement as opposed to the evidence.
So the introduction of the idea that they work for the Organized Crime Bureau, is it your point that they should not be able to discuss what unit they work for? Because those units, right, they're rarely going to have simple, gentle, kind names. I mean, there's the narcotics unit. And so would it have been different if these officers had worked for the narcotics unit and they introduced themselves and says, yes, I'm a member of the narcotics unit? Would that have been just as problematic?
It wouldn't, Your Honor. The problem here was the disconnect between the name of the unit and the charged crime. So you can imagine saying that an officer works for the narcotics unit in a drug trial, works for the homicide unit or the major crimes unit in a murder trial. That's not filling any sort of gap. The jury knows that this is a murder trial and this is a drug trial. But the organized crime unit, that has, gang affiliated, gang connotations. This wasn't a case where Mr. Butler was charged with any gang-related offenses.
He was charged with conspiracy.
Conspiracy, but that's something different from some more, leader of our narcotics trafficking network, promoting organized street crime, gang criminality, racketeering, leader of organized crime. Those are other crimes where it might have been more appropriate for the officers to say they work for the organized crime unit. But conspiracy doesn't necessarily mean that the defendant is involved in gang-related activity, and the state needed to provide evidence that he was involved in gang-related activity if they wanted to use that to support a conspiracy conviction, which they didn't do here. So the issue is that the use of the organized crime unit is, allowing the jury to speculate that Mr. Butler is involved in gang-related activity, and that's why he was investigated by the organized crime unit, and therefore made it more likely they would have convicted on something such as conspiracy, not based on the evidence, but based on the name of the unit.
Counsel, is this particular argument about the use of Organized Crime Bureau identifying the unit your strongest argument?
it's one of many arguments. So I mean, I don't think that this was I think the use of the wire, the testimony about the warrant, which I'm going to get to, and
Let's focus on the other arguments.
okay, and the details about the size and scope of the investigation about it was in gun violence in response to shootings. I think all of these things really work together to just make it seem like there was other evidence outside of what was presented to the jury that
Sorry,
were
Chief, I had one question
incriminating.
about this argument. The appellate division seemed to say that it had to be reviewed on plain error because it was unobjected to trial testimony, suggesting that defendant was involved.
So they're saying that the trial counsel didn't preserve the error when it happened. They didn't object to, I guess, whenever some or maybe more than one witness took the stand and they're introducing, hey, where do you work? And they say this long division name that implies they investigate people like the client, like the defendant, for organized crime. They didn't object and try to find a way around it at trial.
Involved in crimes investigated by the Organized Crime Bureau, but you would oppose that because there was an objection to any reference to the Organized Crime Bureau or large scale organized crime investigation, correct?
Yes, that was all objected to before trial, and the court ruled that it could come in. So that would be reviewed under harmless error, not plain
Can I
error.
Was there
just stop?
supposed to be,
Go ahead.
I'm sorry, was there some conversation about limiting instruction? What happened there? It seems like that just fell away.
There was the court offered a limiting instruction, and the defense attorney said, let me think about that and whether it would highlight it more than I would want it to be. And then there was never any limiting instruction. So I think we can infer that defense counsel made, I think, a fair strategic decision not to draw more attention to the organized crime unit than was necessary. The same exact thing happened in State versus Williams, the Shining case, where the defense counsel objected to the use of the Shining, and both the court and the defense counsel agreed that a curative instruction would actually do more harm than good because it would just draw more attention to the prejudicial issue. And so I think
Do you have an argument as to that today, whether or not the court should consider limiting instructions on situations like that, where for many different reasons, the names of different squads or units of the police department or law enforcement agencies could be used and throughout the course of trial, and rather than to have to object and stop at each turn, that perhaps an instruction should be given to the juries generally?
And perhaps an instruction could be given to juries that, the jury shouldn't draw any conclusions about the guilt of the defendant based on the name of the unit. But I think it may be best dealt with on a case-by-case basis, because I do think it was fair here for the defense counsel to say, I'd rather not have a limiting instruction because I don't want to draw more attention to the name of the unit than necessary. So I think I would leave that to the discretion of the defense attorney to decide based on the facts of the case. The final issue I would like to talk about is the improper warrant testimony before, again, turning to talking about cumulative error and the specific harm in this case.
All right, and I wanted to actually get some background from, before she goes into this issue, I think it's easier if we read how it's written. This is from the opinion. We'll read more from the opinion later, but, they always start off with a background. And I think it's going to be helpful to frame by letting us know some of the motions in limine before trial and what the state did anyway, even though a motion in limine was granted, that they weren't supposed to be saying certain things. So here, in this appeal, the court considers defendant Gerald Butler's challenge to his conviction for controlled dangerous substances, CDS, offenses on the basis of prejudicial prosecutorial comments and the admission of evidence Butler contends portrayed him as a violent organized criminal. Cumberland County Prosecutor's Office Organized Crime Bureau, which is what they didn't want mentioned, launched an investigation in response to a series of shootings in Millville. So, organized crime, shootings. This is just like The Wire. Butler was not linked to any of those underlying incidents of violence. He became the subject of investigation only after surveillance of wiretapped lines captured a phone call during which the participants discussed facilitating a firearm purchase. Police obtained a warrant and searched an apartment they had seen Butler entering. They found heroin, cocaine, drug paraphernalia, and 2 revolvers. The leaseholder of the apartment initially attributed one of the revolvers to Butler, but later recanted. Butler was arrested. Before trial, defendant moved to sanitize references to search warrants, which is, we're going to hear this argued now in front of the Supreme Court. The court instructed the state to use the phrase lawful search and not to mention search warrant. The state agreed. Defendant also sought to preclude references to the OCB, so the Organized Crime Bureau. The state offered to craft a limiting instruction, which Butler considered but never pursued. As she just explained, the trial counsel probably thought that the instruction would just highlight the elephant in the room again. So, during opening statements, the prosecutor made multiple references to The Wire, a television show widely known for its portrayal of organized crime. Defendant's immediate objection was overruled. So this is something that was actually preserved. When we're getting into the lawful search and search warrant argument we're about to hear, yeah. Throughout the trial, the state's witnesses, many of whom identified themselves as members of the Organized Crime Bureau, made references to gun violence, weapons trafficking, and organized criminal activity. Despite defense objections, the state questioned witnesses about the search itself, resulting in repeated references to the, quote, search warrant. Butler was acquitted of weapons offenses but convicted of CDS offenses. The appellate division affirmed defendant's convictions. And then, obviously, we know that the state Supreme Court is going to reverse and send this back for a retrial. So the conviction is now overturned. So back to her argument.
As your honors are aware, the bulk of the state's case turned on Butler's connection to apartment 16D. And so any improper testimony strengthening his connection to that apartment was highly prejudicial. That's exactly what the
And actually, let me rewind it because since we stopped at the middle.
Had to be reviewed on plain error because it was unobjected to trial testimony, suggesting that defendant was involved in crimes investigated by the Organized Crime Bureau. But you would oppose that because there was
feel
an
like that
objection
jumped a
to
lot.
any reference to the Organized Crime Bureau or
let me think about that and whether it would highlight it more than I would want it to be. And
Yeah, that jumped a
Should be
lot.
given
Sorry.
Williams, the Shining case.
Many different reasons, the names of different squads or units of the police department or law enforcement agencies could be used. And throughout the course of trial, and rather than to have to object and stop at each turn, that perhaps an instruction should be given to the juries generally.
Perhaps an instruction could be given to juries that, the jury shouldn't draw any conclusions about the guilt of the defendant based on the name of the unit. But I think it may be best dealt with on a case-by-case basis, because I do think it was fair here for the defense counsel to say, I'd rather not have a limiting instruction because I don't want to draw more attention to the name of the unit than necessary. So I think I would leave that to the discretion of the defense attorney to decide based on the facts of the case. The final issue I would like to talk about is the improper warrant testimony before, again, turning to talking about cumulative error and the specific harm in this case. As your honors are aware, the bulk of the state's case turned on Butler's connection to apartment 16D. And so any improper testimony strengthening his connection to that apartment was highly prejudicial. That's exactly what the improper warrant testimony here did. 4 separate times, the prosecutor elicited testimony that Butler was the target of the search warrant executed on 16D. And this harm, the harm from this type of testimony was articulated in State versus Milton and State versus Alvarez. In both of those cases, the defendant was charged with contraband found in a house that he shared with others. And in both of those cases, the defense was that the contraband could have belonged to one of the other residents. In that context, testimony suggesting that defendant was the target of the search required reversal because it suggested additional evidence was presented to a warrant issuing judge that wasn't presented to the jury. That's exactly what happened here. Butler was charged with contraband found in an apartment where he and many others stayed. Butler's defense was that the contraband belonged to someone else. And while the jury heard some evidence connecting Butler to apartment 16D prior to the issuance of the warrant, this evidence was far from overwhelming. So testimony that the warrant targeted Butler specifically when the jury knew the apartment was used by others invited the jury to speculate about additional evidence presented to the warrant issuing judge that pointed to Butler. Butler was also prejudiced by repeated and unnecessary testimony about the existence of search and arrest warrants. In State versus Kane, this court reminded prosecutors that while a search warrant can be referenced to show that police didn't act arbitrarily, repeatedly mentioning a search warrant can permit an impermissible inference of guilt. In Kane, this court found that mentioning a warrant 15 times in opening, summation, and questioning went well beyond what was necessary, had little probative value, and had the capacity to lead the jury to draw an impermissible inference that the court issuing the warrant found the state's evidence credible.
I thought Kane said that there couldn't be repeated mentions that a search warrant was issued by a judge.
in Kane, I believe only some of the references to the search warrant said that it was issued by a judge, and that made it even more prejudicial. But
Let's stop for a second. How many references altogether to the existence of a search warrant, and how many references to the fact that a judge authorized it
in Kane,
in this case?
there was no discussion of the fact that the judge authorized the warrant, but there was 7 mentions of a search or arrest warrant, and 4 times there was testimony elicited that defendant was the target of the search. And so there was no, in Kane, what this court emphasized is that the purpose of introducing a concept of a search warrant, or the fact of a search warrant, is to show that the police didn't act arbitrarily. But here there was no dispute that the police, acted lawfully. And in fact, before trial, all the parties agreed to follow Kane and to refer to the search as a lawful search as opposed to referencing a search warrant. But here we have kind of I'd call like a combination of a Kane and a Milton Alvarez problem, where there was unnecessary repeated references to search and arrest warrants that many of the jury members know those are issued by a warrant issuing judge, and so could cause the jury to speculate that a warrant issuing judge found the state's evidence credible. And also a Milton Alvarez problem where there was very little evidence connecting Butler to the apartment 6D, especially as opposed to all the other people who used 16D prior to the issuance of the search warrant. So the fact that he was the target of a search warrant could have led the jury to also speculate there was additional evidence outside the record incriminating Butler that wasn't presented to the jury.
How does it factor into your analysis that he was acquitted of one of the charges of evidence that was recovered post-search?
I don't think that impacts my arguments. That gun was found underneath a couch where another person was staying at the time of the search. And so Butler had a really strong argument that gun belonged to someone else.
But doesn't it support the idea that the jury was able to independently make a determination of the evidence and evaluate it all properly and wasn't unfairly influenced by the state's repeated comments on the warrant issue?
I think the court's repeated comments on the warrant issue and Butler being the target, in addition to all of the other testimony suggesting that he's part of some violent gang, the fact that the jury acquitted of the gun charge, as I mentioned before, like Butler had a strong argument of a third-party guilt on that charge. It was a less clear argument of third-party guilt on the other charges. So the fact that he was the target of the search warrant as opposed to someone else, and that the use of organized crime, the wire, wide-scale investigation into.
I think it's a great question from the justice. I think she's flubbing a little bit here, I think she's kind of wobbly. But what she's saying is that distinction, because it's not as clear-cut, makes it all the more important that the prosecution was leaning on these other, extra statements to fill in gaps. So they're making mentions of organized crime. They're talking about being targets of the search warrant. They're making references to shows that bringing drugs into the community. Those are things that are unrelated and stemmed from a fiction TV show that can fill the gap for the jury to conclude, hey, what about this contraband? Could it have been his?
Gun trafficking and weapons trafficking. The jury could have found that even though he didn't possess that one gun that was, underneath a couch where someone else was sitting, he was more likely to possess with intent to distribute the drugs found in the apartment because he was the target of the search. And there were all of these references that made it seem like he was using 16D as some sort of headquarters to operate his, drug dealing gang activities. I'd like to also touch specifically on harm and cumulative error in this case and talk about the specific charges.
All right, so this is going to be painting the whole picture, why all of these things together? Because again, the filling the gaps thing is important. All of these little things here and there, sure, one thing might not tip the scale either way. But if the prosecution needs to fill gaps using references to third-party cases, to pop culture fictional TV shows, that isn't the right way to meet their burden. So you can see that there's a lot of time here left. We're going to see the reverse arguments. I think one of the amici argues. I saw it like a third person here. Before we get into that, though, I want to thank Moses for the super here. It says, good morning to everybody. I'm on vacation in Houston, please eat lots of good food. That's the first thing I think of when I think of Houston. So eat lots of good food and tell us about it and enjoy yourself.
Because to obtain a conviction, the state needed to prove beyond a reasonable doubt that Butler possessed with intent to distribute contraband found in 16D, sold drugs to Joshua Phillips on one occasion, and conspired to commit those crimes. The issue is that the state's case on each count suffered from evidentiary holes. Regarding 16D, no one saw Butler possess the contraband found there. Much of the evidence suggested the contraband belonged to someone else. Butler wasn't there when the apartment was searched. The apartment was leased to a different person. Many people stayed there, and much of the contraband was found in another person's personal bedroom. So any error suggesting that Butler was a criminal gang member and strengthening his connection to 16D made it more likely the jury would convict him of possessing with intent to distribute the drugs found there.
Yeah, because it's all of theirs. They all have
Regarding the
access to
suspected
sell.
sale on one occasion, the evidence there was also problematic. The surveilling officer couldn't see the seller or any money or drugs exchange hands. The out-of-court identification of Butler as the seller was problematic, and his testimony identifying Butler as the seller in court was tentative. He said Butler may or may not have been the seller. So again, the errors making it seem like Butler was a criminal gang member using 16D when the sale happened close to 16D could have influenced the jury's verdict on this count as well. Finally, I just want to touch upon conspiracy. There was really no evidence in the record that Butler was working with others to possess with intent to distribute drugs as part of a conspiracy. To the extent the text showed anything, they showed individual drug transactions, which, as the appellate division even recognized, is insufficient to establish a conspiracy under Wharton's rule. I think it's kind of helpful to compare the evidence in this case to State versus Roldan, where the appellate division found sufficient evidence of a conspiracy. And there was 700 pounds of cocaine being transported across state lines. Everyone was reporting to their supervisors. There was $250,000 of drugs at issue. That's just like simply not what we were looking at in this case, where at best the evidence supported individual sales. So again, any evidence suggesting that Mr. Butler was a gang member, was connected to 16D outside of the record, could have influenced the jury's verdict on conspiracy as well.
When
yeah.
you say references to Mr. Butler was a gang member, is that just because of the reference to them working for the Organized Crime Bureau, or were there more specific references to Mr. Butler as a gang member?
The combination of the wire, the indication of the wire, organized crime, and then also just that this was a large-scale investigation into weapons trafficking and weapons trafficking and narcotics trafficking. That there were multiple people being investigated as part of this investigation. Multiple people were arrested on the same day as Mr. Butler. Again, none of this was admissible evidence, but together I think led to kind of a common sense conclusion from the jury that Mr. Butler was involved in some sort of gang-related or organized crime.
It sounds to me, if you remove all the gap fillers, what's left of the case would be you have an apartment that's leased under somebody else's name, where a bunch of people stayed at. And yes, Walter was there, or Butler was there on occasion. He wasn't there when this stuff was found there. And the stuff was found in the house in different places in the house where multiple people were, and not Butler. And then we have a wiretap where he's talking about trying to sell a limited amount of contraband that's not necessarily the same exact contraband that's recovered from this residence. That's what would be left of the case.
Thank you, counsel. We'll have you back for rebuttal. Mr. Rosenberg?
May it please the court. Rarely is there sufficient and legitimate justification for a prosecutor in opening statement. Well, I should tell you, legitimate and sufficient justification that outweighs the potential for prejudice for a prosecutor in opening statement to make the sort of wholesale analogy to a case that is not before the jury, particularly something like a fictional case, in this case, The Wire. And I'm not talking about simply references to popular culture. I'm talking about what happened here, which was, as Justice Wayner Apter went through, a fairly detailed summary of the facts that are set forth in a work of fiction and telling the jury that this is similar to this case. And there's at least three reasons why that is uniformly not permissible. The first is, by definition, the prosecutor is going outside the evidence. When the prosecutor is detailing what happened in a work of fiction or some other work of popular culture and telling the jury that's similar to this case. When the prosecutor says this case is similar to that case, that in itself is a statement of purported fact. And here, even this morning, we had a discussion all of a sudden as to whether the wire was about also police misconduct, in addition to being about ganglands. And that is not what is supposed to be happening in the trial of the case before the jury. They're not supposed to be debating what happened in a work of fiction. They're supposed to be concentrating on the case before them, which is a second point. When you're asking the jury to conjure up facts relating to fiction, you're really dealing with a recipe for prejudice, and particularly in the opening statement. The opening statement has outsized influence over juries. It sets the thematic framework. It constructs a prism through which the jury is going to be assessing all of the evidence. And by raising this gross similarity of a work of fiction with the case before the jury, the prosecutor is asking the jury to view the facts through that prism of the work of fiction, and that's improper. And third, it's just not necessary. It's really difficult to conceive of circumstances where it's necessary for the prosecutor to tell the jury that this case is similar to a case that's not before the jury. And this case here really illustrates that quite vividly. Justice Weiner-Apter went through what was essentially the first third of the argument of the prosecutor here. And by the end of that, I guess it was 7 or 8 sentences, not one of which dealt with the evidence that was actually going to be presented by the prosecutor at trial, it is reasonable to assume that at least one, if not most of the jurors, thought that this.
Okay, guys, this is Ezra Rosenberg. He's the director of appellate advocacy for the ACLU's New Jersey branch. So this is one of the two amici, whatever. You guys know what I'm talking about. The Friends of the Court filings that were filed. Both of the filings were on behalf and in support of the defendant. And both, they're taking issue with use of pop culture references in trials. If we hear the guy from the New Jersey Actal, he's going to hammer hard. The brief hammered pretty hard on prosecutorial misconduct in general. So hopefully we get to hear them speak. But that's why it sounds like they're supporting the defense, because in this situation, they filed their briefing in support of the defense's arguments.
Case was about drug-laden gangland violence, and that Mr. Butler was at the center of it. And that, as the prosecutor says in his brief, the prosecutor did not specifically compare Mr. Butler to Avon Barksdale or Stringer Bell or Omar Little. What the prosecutor did was essentially compare Mr. Butler to all of the characters in The Wire. The prosecutor also says that, well, this was helpful to instruct the jury on the complexities of obtaining a wire intercept. The entirety of what the prosecutor did in that regard was 2 sentences that say the only way to really find out how the guns and drugs were flowing in the community was to get on the person's phone, referring to what happened in The Wire. So they got an intercept known as The Wire. That's
The
it.
person's phone.
And then prosecutor goes on to say, that's similar to this case.
That's correct.
And that's what the prosecutor is saying is similar to this case. The prosecutor isn't saying all these things that I've said about violence.
But the important part of that sentence is important. They need to figure out how all of these drugs are flowing into the community. They figured out they got the person on The Wire. And then the prosecution is going to argue this person's on The Wire. If you remove the first part of that sentence, you can pretend that this is a pertinent question. But the first part of that sentence exists.
Violence in the area are what is similar. What the prosecutor said is similar is that we use a wiretap to investigate.
And I appreciate that, Your Honor, but leading up to that.
Tell him,
saying
Ezra.
That's similar to this case, are about 10 sentences detailing the violence in the city of Baltimore, the hierarchy,
Let's go, Ezra.
that there was someone who was giving orders, all of that leading to the
10
implication
sentences.
that this case is obviously this has to do something with this
So you're
case.
saying that that's similar to this case refers to those 10 lines behind and not the immediately preceding point?
I'm saying two things. I'm saying, one, the way it was structured with the prosecutor starting off with this detailed summary of violence and a hierarchical organized crime in Baltimore, and then saying, so we have to find out why the guns and drugs were flowing into the city of Baltimore, so the people on the wire got a wire intercept. That's similar to this case. That kind of says to the jury, everything that came before it is similar to this case. But beyond that, there was no reason for the prosecutor to go into that detail to supposedly instruct on the complexities of getting a wire. All they said is, we have to find out who is behind this, so we got a wire. You don't need to go to another case, either work of fiction or some other work of popular culture, for the jury to understand that.
Is the language that followed problematic as well? Because after saying that's similar to this case, which arguably referred backwards in time, there's then a description about why the organized crime unit did it in this case, because there was a rash of violence, paraphrasing the very same words, that was happening throughout Millville and throughout the summer of 2016. Is that of concern as well?
Absolutely, absolutely. The entire opening, the entire opening statement was to set this picture of violence, gangland violence, drug-connected violence, with someone at the center, and that someone in the juror's mind naturally would be Mr. Butler. And then the prosecutor also says, well, we needed it in order to explain to the jury that targets sometimes tell on themselves.
Yeah, and remember, the whole key here is Butler was charged with and then convicted of drugs, contraband that were recovered from this residence while he wasn't there. This isn't like they did a traffic stop and patted him down and he's the only one driving a car, and sure, the pills were under the seat, but you're the only one in this vehicle presently. Oh, I didn't know they were there, which there could be problems there, but it's a little less ambiguous. If you're the registered driver of the car, you have to fight harder for those types of cases. This is a situation where he's charged and convicted with drugs that he was not found with. They found it in a place and decided to charge him and not any of the other residents in that house. So the reference to, we found the guy, just like this case, it's bringing drugs into the community in opening statements. It's exactly as Ezra's pointing out here, that the jury's naturally going to visualize Butler when they make that statement, comparing it to The Wire. Yes, this is Amicus. Yep. This is from, what was his title? Director of Appellate Advocacy for New Jersey, for the ACLU New Jersey, I think was his title. So Ezra D. Rosenberg.
Now, I don't think the jury necessarily needed to be instructed that sometimes people self-incriminate when they don't know they're being overheard. And you certainly didn't need to tell that from a television show. And just because it happened in a television show doesn't necessarily mean that it's true. So this goes back to the point that this isn't necessary. And there's this potential for prejudice. So I think this court has to really, I know it's done in the past, instruct prosecutors that they have to be very careful before they make these kinds of analogies. Now the prosecutor also says, well, this is nothing worse than explaining to jurors that northeast winters are very severe by referring to The Shining. And I was actually surprised to read that. Would have thought they could have come up with maybe a more helpful analogy for themselves, something maybe White Christmas, or if I'm dating myself, maybe planes, trains, and automobiles. But The Shining, I mean, do we really think it's appropriate for prosecutors whose duty is to ensure justice to say something to a jury like, this case begins on a cold, wintry, snowy night in Millville, just like in The Shining? Is that really what prosecutors are supposed to be doing? I think not. You know, yesterday I was here listening to the argument in Mustafa, and all of a sudden the DIG stood up and said that when he was arguing, he said that he wanted to talk about an analogy to a movie Sling Blade. And Justice Patterson, I didn't see the movie either, but he described it as a movie dealing with a person who had epilepsy, who was convicted or who actually murdered someone. And he was using that to discuss the issue of whether or not there can be a diminished capacity defense for certain medical conditions. And it really struck me, and I know you all are not a jury, but there's a real slippery slope when you allow the use of analogies, and it's not simply references, it's analogies saying this case is just like that case. Prosecutors should not be allowed to do that, and I would ask the court to please issue guidance to that effect.
I have a question with respect to your position on search warrants in this case, but I just want to say one thing, and please don't take this as chastising you. I'm mindful of what might evolve in the Mustafa case. The court will not consider your comments. Allow me to finish.
Yes.
The court will not consider comments that you just made with respect to that argument and its deliberation on that matter. Please go ahead.
Yeah, and I.
It wasn't intended that way.
It certainly was not intended at all to deal with the merits of the arguments in Mustafa.
Would you spend a moment on your position on testimony with respect to warrants?
We've not briefed that. We
Sorry.
we rely on
It's been
Ms.
the
Gifford's
ACBL.
argument to that effect.
Right. Thank you.
Thank you very much.
Mr. Sayre, why don't we start? It's 12:15, and we will do our best to get through the argument, although not by 12:30. If it looks like that's a false hope, we may stop and resume it a little bit later. Please go ahead.
Understood, Your Honor. May it please the court. This case asks whether brief contextual reference is made to median and opening statement without direct or arguably general comparison to a defendant constitutes reversible error, as well as whether the usage of the name of the investigating unit in this case and whether certain references to the defendant being the target of a search warrant in this case constitutes reversible error. It is the position of the,
if you could.
I'm sorry, Your Honor. It is the position of the state that the defendant did receive a fair trial in this matter. I'd like to start with a discussion of the prosecutor's reference to the television show The Warrant in this matter. It is the position of the state that it is neither improper nor prejudicial what the prosecutor did in this matter. To address what was raised a moment ago, the reference to The Wire was made as part of the prosecutor's opening argument in this case, setting the initial impetus and scope of the initial investigation. She was talking about how there was certain criminality in the city of Millville, and the investigation was into these incidents that specifically she mentioned did not involve Mr. Butler, and that ultimately Mr. Butler was brought into this by being heard on one of these wiretaps going into these other individuals who weren't Mr. Butler, being contacted about trying to purchase a firearm in this matter. Ultimately, the reference to The Wire was about articulating the purpose and functionality of a wiretap, and that was part of it. It was explaining the circumstances in which a wiretap needs to be brought in because it's particularly useful under these circumstances, as outlined at length in those initial preceding statements by the prosecutor in this matter. It's also part of a
Two questions about that. Where specifically did the prosecutor say that the defendant was not a part of, quote, a rash of violence that was happening throughout Millville and throughout the summer of 2016? That's from the opening, where
yes.
she says, this is happening. She said defendant was not a part of that. I see where she says that defendant was not one of the original 4 individuals who they got a wire on, but I don't see where she says that defendant was not a part of a rash of violence that was happening throughout Millville and throughout the summer of 2016.
That is accurate, Your Honor. My intended statement to that effect is that what the prosecutor was saying is that this initial investigation was started because of this rash of violence in Millville. And she clarifies that those individuals that were being looked into as a result of this were not the defendant, and that the defendant ultimately became a part of it when he was heard incidentally on the wire.
But why is even that not problematic? So as Amiki pointed out, the point of an opening is to create a prism through which the jury will view the evidence. Here, there was evidence of a drug transaction and possession of drugs and a conspiracy to engage in the drug transaction. Why is it okay to say, I just want to give you the larger context for this case, and the larger context for this case is a rash of violence that was happening throughout Millville throughout the summer of 2016? Isn't that creating for the jury a prism that they should see the defendant as part of this rash of violence, especially when the prosecutor never says, and that had nothing to do with the defendant, but.
It would be the position to say, it's not that the reference to the wire was necessary. It wasn't necessary, but it was helpful. And the consideration for the court in reviewing whether it was improper is, I believe it's Stevie Wakefield and Stevie Papasavas, where the standard that the court is to assess is not whether it was necessary, but whether it was so egregious that it deprived the defendant of a fair trial.
So let's go back to basics for a second. This defendant was charged with particular allegations, particular offenses, as to which it was entirely appropriate for the state to introduce evidence that bore on the charges. But he was not charged with committing a rash of violence and unspecified gun violence in the city. So how is it appropriate to inject comments in the opening and in the closing with respect to that?
Right, because these references were defining the origin and scope of the investigation, which would be
Wait,
helpful.
could you keep your voice up, please?
Sorry, this was about the origin and scope of the investigation. It was helpful to the jury to articulate how the defendant became involved in the investigation.
So let me ask you about a passage in closing with that in mind. The prosecutor says there's a huge wide-scale operation known as That's All Folks, references a call that was listened to, and then says, it's going to be up to you to determine what was that call about in the context of the overall investigation, which you knew it was about gun violence in the city of Millville. Is that appropriate? Was that something that the jury needed to determine as it evaluated the call?
I think that goes to what the appellate division referred to as being unnecessary language. And it certainly was unnecessary, but it is the position of the state that this did not deprive the defendant of a fair trial. It's not.
Is it more than unnecessary? Was it inappropriate for the state to present that question to the jury?
It would be the state's position that on the record in this case, it did not deprive the defendant of a fair trial. It wasn't so egregious as the standard would state because of the
Was
record.
it inappropriate?
That it is not inappropriate for that remark in the summation would be unnecessary and not ideal, but
Was it accurate? Is that what the jury's responsibility in this case was, to determine whether a particular call, how it fits into the context about an investigation and relates to gun violence in the city of Millville?
it is accurate in the sense that it is asking the jury to assess whether the defendant essentially, as she said in the opening, told on himself. To that extent, it is calling for the jury to make a position as to the sufficiency of the evidence against the defendant on that point.
I'm afraid I don't understand that. I understand the first part of the comment. Up to you to determine what that call was about. I don't understand the relevance that the prosecutor was then asking the jury to determine here.
Just ask it in a different way. Wouldn't it be unfair for the prosecutor to say, in considering whether the defendant committed this particular crime, you have to consider his relationship to this huge wide scale operation known as That's All Folks, which had been described throughout trial as a rash of violence happening throughout Millville. Is it fair for the prosecutor to say, in determining if defendant committed these very specific crimes he's charged with, you have to consider this huge rash of crime in the city of Millville, and it had a special name and it was a wide scale investigation? Is that fair?
I think that is largely mitigated by the fact that throughout the trial, whenever this discussion of the violence in Millville was brought up, particularly by the testifying witnesses, it was clarified that these instances did not involve the defendant, Mr. Butler.
But then the prosecutor specifically is connecting them to the defendant, as the chief pointed out, by saying that it's up to the jury in the context of the overall investigation, which you knew it was about gun violence in the city of Millville. So the prosecutor is doing the opposite of saying this has nothing to do with the defendant.
That is the case. Given the totality of the references to this criminality in the state of Millville throughout the trial in this matter, the position would be that the jury was repeatedly reminded that the defendant was not involved in these, and this unfortunate remark in summation does not necessarily, given the totality of these references, rise to the level of denying the defendant a fair trial.
In addition to all of these, as I see it, substantial problems with the reference to the wire and so on, was there a pretrial order precluding any reference to the warrant as a search warrant?
Yes,
And was that pretrial order violated?
the pretrial decision to bar references to the search warrant was obeyed in spirit, in the sense that if you were to look at the, and I don't mean to stray from the wire issue initially too much, but the references to the search warrant in this case, I believe there were 4 references.
All right, I'm going to do a quick pause and maybe we'll do, gosh, this is like, speaking of the wire, this is like right running up on the wire. Factual Lie tagged me in a post from Colin Miller. And we talked about watch parties. Maybe we'll do a listening party over in Discord to listen to Colin's new episode. I'll share it when it drops. He says he's sharing he's recording a special undisclosed podcast with the legal team for Sonny Burton, who faces execution on March 12th. That's right around the corner. Despite 6 out of 8 living jurors and the victim's daughter calling for clemency. So, especially if you're in Alabama, I'm going to drop this link in the chat right now. It's charlessonnyburton.com. Especially if you live in Alabama, there's some templates where you can send a note to your state rep. It takes you to a really simple way to find your state rep and gives you a phone script so you can call and leave a message for Governor Kay Ivey. If you are not an Alabama resident, there's options for you to share and sign petitions about his story, taking the death penalty off the table for him. Dropping that in the chat. And when you get there, you'll scroll, you'll see this, like, you can quickly choose your own adventure. I live in Alabama, I live in another state, I live outside the US, and it'll take you to available options for you to help support. So that's on my radar now. I'll definitely share when his episode drops. I'll look into the details of the case, and maybe if we can get together this weekend, we can talk about it, because that's kind of crazy. And just because it's only a few days away does not mean that it cannot be stopped. The tragic end result for Marcellus Williams, he was ultimately executed, but initially, in the final minutes, his previously scheduled execution was stayed because of the social media, like, outlash and reaching out to different politicians. So it can make a difference. So if you're so inclined, please take a second to click that link. Let me see. And just double checking, I don't see that Colin's posted anything more recent for the podcast, but he does have some context. So his attorneys note that despite 33 years on death row, he remains a positive presence on the unit, is well regarded by prison staff and officials, and is a strong source of guidance and support for younger men both inside and outside the prison. Sonny admits being involved in the robbery that led to Derek DeBruce fatally shooting Doug Battle, but he had left the store before the shooting. DeBruce has had his sentence reduced to life without parole. So the guy that I've read about this. I was reading this case. And the whole idea is, what is fair? I was going to do a stream on this. I feel so bad that I didn't now. The idea of what is fairness. Is it fair? Say there's overall you have this robbery where someone ends up murdered. The guy who's actually in the store with the gun and pulls the trigger and kills the person, their sentence is reduced to life without parole. The death penalty is removed. But somebody who was part of the robbery but not even in the building anymore when the shooting takes place is still facing execution. Oh my gosh, I feel so bad that I didn't do something on this. I was just reading like the appellate arguments. I didn't know it was at this stage. He goes on, he says, I didn't even know anybody was shot till DeBruce told me he had shot a guy after we left the store, Burton said. I was so mad. So there's some context. And let me share this Newsweek article in the chat as well. And it was just going to be like, oh, here's an interesting appellate argument. What is fairness? Here's an interesting question, you know. If it's reduced for one, should it be reduced for someone else, especially if the facts are a little different for the other person? So I'll be keeping my eye out. Let's get back to these arguments. I will continue to share updates as I see Colin share them. And now I know what case it is.
Total to the term search warrant. They were fleetingly over the course of a multi-day trial by the state's witnesses. And
I hate to interrupt you, but all I'm trying to figure out is we have an order that says don't refer to the warrant as a search warrant. Did the prosecutor elicit testimony about a search warrant and violate that order?
in the sense that the witness did erroneously refer to a search warrant that was in violation of the order. However, the
I know,
prosecutor
Chuck.
did not belabor the issue of the search warrant. It
Depressing.
certainly didn't become a theme of the prosecution. The case law seems to suggest that this becomes problematic when the discussion of the search warrant comes up, when it is weaponized by the state as a way to create a judicial endorsement of guilt, because the jury would then know that a judge authorized the issuance of the search warrant. In this case, the search warrant, I apologize, Your Honor, this wasn't repeatedly brought up by the state as a way to make that sort of implication.
Shouldn't have been brought up at all.
It was erroneously brought up. I think the
Oh, that was a zinger. That was a zinger, and it's quiet, so it was a quiet zinger.
case, I believe there were 4 references total to the term search warrant. They were fleetingly over the course of a multi-day trial by the state's witnesses. And
I hate to interrupt you, but all I'm trying to figure out is we have an order that says don't refer to the warrant as a search warrant. Did the prosecutor elicit testimony about a search warrant and violate that order?
in the sense that the witness did erroneously refer to a search warrant that was in violation of the order. However, the prosecutor did not belabor the issuance of a search warrant, and certainly didn't become a theme of the prosecution. The case law seems to suggest that this becomes problematic when the discussion of the search warrant comes up, when it is weaponized by the state as a way to create a judicial endorsement of guilt, because the jury would then know that a judge authorized the issuance of the search warrant. In this case, the search warrant, I apologize, Your Honor, this wasn't repeatedly brought up.
This apology is funnier
as a
now.
way to make that sort of implication.
Shouldn't have been brought up at all.
It was erroneously brought up. I think the record makes it.
Who erroneously brought it up?
I believe that the intention from the prosecutor in asking her questions to the testifying witnesses was
4
not for them
times.
to acknowledge a search warrant. She was talking about a lawful search, and I believe they responded by saying, yes, search warrant.
So prep your
Didn't
witness.
she mention, I'm sorry, the word search warrant once?
Yes, she did mention the term search warrant. That was immediately in response to the law enforcement officer witnesses' usage of the term, and it was a fleeting remark that was made immediately in response to the law enforcement officer witness. This again would go to the idea that this wasn't something that the prosecutor was making a theme of the prosecution in this case, as the case.
What about the defendant's point that it's not only that the word search warrant was mentioned, but that it was repeatedly stated that the defendant was the target of the search warrant, even though, for example, defendant did not rent the apartment that was searched, etc.
I'm sorry, could you repeat the question, Your Honor?
The defendant seems to be arguing it's not only the fact that the word search warrant was mentioned, it's the fact that there was repeated
Targeted.
eliciting of testimony that the defendant was the target of the search warrant, even though he wasn't there at the time of the warrant, he didn't rent the apartment that was searched, etc. So trying to tie the defendant to everything found in the apartment.
Case law seems to problematize this target language when it is about creating the implication of undisclosed evidence. I believe this is what State v. Milton and State v. Alvarez is about. In this case, the reason there isn't the same capacity for prejudice as those cases is because there was a discussion that was put in front of the jury before any language of the defendant being the target, that this was preceded by the state's showing of what led to the issuance of the search warrant. By the time that they heard this target language, they had already heard recordings of the defendant and his voice being identified by an officer and by its connection to Facebook and by him calling himself Mr. Butler online, his voice arranging for the sale and distribution of controlled dangerous substances. So where there isn't the capacity for there being a implication of undisclosed evidence that led to the issuance of the warrant, this would be a case that differs from State v. Milton and State v. Alvarez in that significant way.
Do you agree that both with the issue regarding the warrants as well as the commentary during opening and closing that there were objections made and that we should be looking at this under harmless error, not plain error?
The record seems to reflect that there were multiple instances where it was not objected to. There are arguably instances where it was objected to. It is a combination of
Which one are you referring to right now?
the references to violence in the city of Millville, as well as the, I'm sorry, were you referring to the
The warrant comment we were just
Right.
talking about.
With a warrant, it would be a harmless error analysis, where it seems that there were spattered objections on that basis.
And the opening and the closing?
The opening and closing, the standard of review would be based on State v. Wakefield and State v. Pavasavas, which is.
Sorry, please slow down and keep your voice up.
The question would be whether the statement was so egregious that it denied the defendant a fair trial. And it was not, it was.
Say no objection in those cases.
Yes.
There was an objection, sorry, to the opening, right?
There
But
was
you're just saying it
ultimately-
doesn't matter for the purposes of the
Yes,
standard
because
of
it does
review?
not rise to the point of being so egregious that it denied the defendant a fair trial. Your Honor, to briefly jump back to the issue of referring to the wire in this case, we discussed that the state's or the defendant's primary reliance on that subject is State v. Williams. It is the case that the circumstances of this case are very, very clearly distinguishable from State v. Williams, where the prosecutor in that case was showing a picture of a murderous, villainous character wielding an axe and trying to make an argument in favor of the thesis that actions speak louder than words, that the defendant in that case had a similar criminal propensity to the character, and for that reason, there was a moral equivalence between them. In this case, the prosecutor did not make any specific or general reference to any characters. The prosecutor was merely invoking the concept of a television show to explain the purpose and functionality of wiretaps.
Let me just change it a little bit, just to go back to the chief's point earlier. If you remove the reference to The Wire and any fictional product, was it appropriate for the prosecutor to sort of lay out her opinion of what was happening in Millville at the time and sort of describe the condition of the city and the violence and all of these features without making a reference to a fictional program? Would that have been appropriate?
It would have been appropriate because it was providing necessary and important context for the jury to understand the context in which the defendant's criminality became known to.
Why
What
though?
Sorry.
Sorry,
Without-
go ahead.
What elements of the offenses charged here do any sense of violence in the community have to do with the crimes charged against this particular defendant?
It does not relate to elements of the crime, arguably, aside from the conspiracy charge, but without providing a context for how the officers came upon the defendant in this case, The implication could be that that the state was engaging in arbitrary surveillance.
No, I'm sorry. Why could it not have been, the state had a wiretap for a particular investigation, and as part of that, defendant was caught or heard doing X. I'm just not sure why it is. I understand why the state would want to say this was part of a large investigation into a rash of violence, but it seems like the state would only want to say that so that the jury would assume that defendant is part of that. So where is the permissible reference or the non-prejudicial reference to a rash of violence happening in Millville and connecting that to this investigation and this defendant?
It is prejudicial to the defendant in the sense that any analogy made by the state would be prejudicial. It is providing necessary information for the jury to understand the functionality of wiretaps.
What rule of evidence are you relying on for that? Openings and closings are supposed to relate to the evidence. What evidentiary rule supports the proposition you've just given us?
Your Honor, I'm relying on State v. Wakefield and State v. Papasavas for the idea that the reference, while not tethered to a specific evidentiary rule, did not deny the defendant a fair trial because it wasn't at that level of egregiousness.
Is it because the state was trying to explain how it is that the defendant was introduced into this situation? Because the initial call was not on a call on which the defendant's phone was up on, right?
Yes.
It was so, and that, I think that's what we're all struggling with is I understand that the state needed to explain how it was that the defendant was introduced into this because there was a bigger investigation and there was a collateral phone call that came in. But I think the question that everyone is struggling with is there's a lot of detail for a case that doesn't involve any of that detail. Now, counsel asked, was that necessary? I'm not sure that's the standard, but it's still an important question.
The state would concede that it was not necessary, but it was helpful. And where the standard is not to determine, it's not that the state can't make remarks unless they're necessary. To the extent that it was helpful, it had a clearly identifiable purpose behind why the state was bringing it forward, and it was not so egregious that it would have denied the defendant a fair
You
trial.
could see it was also potentially harmful.
I think that we can conclude that it was not potentially harmful specifically because of the split verdict that happened in this case.
I'm sorry, because of what?
Because of the split verdict that happened in this case. On this subject, the defense is essentially asking this court to believe that the jury was simultaneously so biased against the defendant because of this reference to a television show that they believed that the defendant had a similar criminal propensity to characters that appear on the
I mean,
show,
there's a reason we don't
such
let
that they found the
propensity
defendant
in.
guilty of the distribution of CDS charge, but simultaneously not so biased as to find the defendant guilty of the possession of a firearm charge. Well,
Are you saying that it's, there cannot be cumulative error if one of the counts in the indictment results in an acquittal? It's not determinative?
Well, the standard for discerning whether cumulative error occurs, my understanding is whether the jury was diverted from a rational appraisal of the evidence. I think that it strongly undercuts the defendant's argument that the jury was diverted from a rational appraisal of the evidence when we see that the jury returned a very discriminating verdict that found
But the specific charge, sorry, that defendant was acquitted of is second-degree possession of a weapon while committing a CDS offense, correct?
Correct.
Okay, and here the gun was found on a couch that someone else, inside a couch that someone else was sitting on, correct?
There was, that is correct, but there was testimony from a witness in this case that the defendant had slept on that couch the night before. And in either case,
It's possible that the jury could have found that the defendant was not specifically guilty of possession of a weapon while committing a CDS offense because the gun was found in a couch that someone else was sitting on, but still more likely to be involved in a conspiracy because of all the references to The Wire and organized crime and so many everyone appears to be going to a place and it appears very hierarchical, etc.
it is absolutely possible, but it does undercut the defendant's argument to the extent that it shows that the jury was finding the defendant guilty where the state had sufficiently proved the charges, and acquitting the defendant where it found the state lacking on that basis.
Counsel, how much more would you like to present in terms of time? Give us a rough sense.
10 minutes, Your Honor.
And let's take a break for a half hour because we'll have rebuttal afterwards, and I don't want to cut into everyone's lunchtime. Our staff is very, very conscientious and patient with us. We will take a break now and resume.
I think the part 2 was pretty short. When I looked, I think it was only like 10 minutes, but maybe I'm imagining things. Yeah, so it's pretty short. Before we get into that, you guys, I did see, and you know, it's like 1 in 20 by the time this happened, but I looked up my notes. So guys, I have a little Word doc, and it's just called To Do Case Coverage, and it's got a bunch of stuff that I wanted to talk about. We talked about the Melissa Sims case. I've got an article I want to talk about. A Florida man blames too early release from jail after stealing $20,000 in laptops, as he uses that as an excuse for why he committed the next crime. So he's saying, hey, you guys shouldn't have released me in the first place, so I shouldn't be responsible for this other crime I committed after, and you're now charging me with. So I thought that was kind of interesting. Got a few jailhouse informant cases. One of them is a Texas federal appeals court in Texas. I don't know the district name or which one. They reversed a Texas death row inmate's conviction. It was Brittany Marlowe Holberg. She was convicted in 1998 of robbing and murdering an 80-year-old man in his Amarillo home. They said that critical evidence was withheld, and another major issue in that case is the state put a confidential, or like someone that was employed by a law enforcement agency. They pretended that they were an inmate and put them in jail with Brittany, and just had that person living in there, law enforcement, working undercover, living as a jail inmate with Brittany. And that's where they end up getting some confession. So that was part of the appeal. I haven't looked at it in detail, but I've got a ton of stuff in there. Anyway, while I was working backwards on my notes about my fundamental fairness stream that happens to have been about Sonny Burton, who is now facing execution on March 12th. I did have this noted here because I was starting to look. Governor Kay Ivey, since she became governor in 2017, she has actually stopped one execution. Just one. But that's more hopeful than zero. So before we resume these oral arguments, I think let's just real quick. This was the story of Robin Rocky Myers on February 28th, 2025. So about a year ago, Alabama Governor Kay Ivey commuted the death sentence of Robin Rocky Dion Myers to life without parole. Myers was convicted. She had a quote here. She says, "I'm not convinced that Mr. Myers is innocent, but I'm not so convinced of his guilt as to approve of his execution." So, I don't know. Maybe she'll do it again for Sonny. So, wanted to share that. And I'll see if I can put together some time to do a good stream, not just like a shoddy, like hodgepodge stream to talk about Sonny's story before March 12th. Let's see. Second part, going back to these arguments. Let's get these captions on. This is a hilarious face. He's like a meme right here.
Your Honor, may it please the court, to conclude the argument I was making a moment ago, I just had two final points that I wanted to touch upon. With regard to the usage of the term, the Organized Crime Bureau in this matter, it is the case that the defendant was offered a limiting instruction in this matter and did not.
Look at this
allow
guy's
that
face.
to happen in this case. But
When
more
you say
significant,
didn't allow, what happened? Because there was a discussion about the limiting instruction and then just no one brought it up again or didn't raise it again.
the court offered to, or specifically brought up itself, the possibility of giving a delivering instruction in this case. My recollection is that defense counsel said, "I'm going to think about that," and then the defense counsel never did bring that up again.
So there wasn't a discussion about defense counsel not wanting to further highlight further highlight the issue.
I don't believe the defense counsel got into it on the record. Specifically on that point, defense counsel today brought up the idea that this was strategic. I would point out that in the defense's summation at trial, defense counsel did weaponize the term of the Organized Crime Bureau itself in bringing up this name. And it seems that the argument the defense counsel was making was trying to imply a lack of candor on the part of the state's law enforcement officer witnesses by making the argument that despite being members of an organized crime bureau and the presumed expertise that carries, they were not able to sufficiently testify with regard to fingerprint evidence. It would seem.
Just to clarify, before trial, defendant did object to any reference to the quote organized crime bureau.
Yes,
And the court overruled that objection, correct?
that is the case, yes.
Usually when a judge or lawyers ask for or discuss a limited instruction, it's because they're trying to address a problem or a concern. Did the judge express what concern or problem the judge had about why a limited instruction may be necessary?
I'm sorry, could you repeat that?
Did the judge explain why a limited instruction may be necessary?
I believe in this case, the judge expressed the offer to deliver the limiting instruction, in this case, in response to defense counsel bringing up the possibility of giving one. I don't believe there was any discussion on the record about any underlying strategic decision being made by defense counsel at the time.
Do you think the failure to follow up on the limiting instruction impacts the standard that we use to look at whether this is, does it change a harmless error to a plain error standard?
It seems that it invokes some level of invited error in this case where
Invited error.
But they objected and the court overruled their objection. And so regardless of why they may or may not have wanted a limited instruction, they did object and the court did overrule. Invited error would be if they had asked the court to allow someone to say organized crime bureau. They did the opposite.
Right. Then to the extent that the defense counsel appears from the record to be the reason why a limiting instruction did not occur in this case. And then defense counsel went on to utilize the term itself. It seems that this undercuts the idea that there was a prejudice that would have existed as a result of any implications from the usage of the term. This also goes to the defendant's arguments with regard to cumulative error in this case. The standard is whether the jury was diverted from a rational appraisal of the evidence. It seems that in this case, we don't have to speculate as to whether the jury was or was not diverted from a rational appraisal. We can see from the fact that they did acquit the defendant where they found the state's proofs to be lacking, that this was a discriminating jury that very closely looked at the evidence and made a decision with regard to or without regard to biases or notions that the defendant was associated with anything that could be inferred from the name of the unit in this matter. Unless your honors have any additional questions, that does conclude my report.
Thank you. Ms. Gifford, brief rebuttal.
Yes, just a few points. I'd like to touch upon the search warrant testimony first, because I counted there were 7 references to search and arrest warrants, and this blatantly violated the pretrial order and the spirit of the pretrial order. The prosecutor shouldn't have elicited this testimony in any way and should have coached the witnesses to say lawful search in accordance with the pretrial order. Regarding Mr. Butler being the
Down
target,
bad, Dennis.
my adversary said that the jury heard wiretaps before the warrant hearing that he was the target of the search warrant of 16D, but those wiretaps didn't connect him to 16D, which is why the testimony about him being the target of that search was so prejudicial. Regarding the Organized Crime Bureau, I think that the record does show defense counsel's strategic concerns. It was page 3 on 3T 27 to 29. That's where defense counsel says, let me think about a limiting instruction and see if it highlights it more than I would want it to be. Then I think the fact that the prosecutor used this, that the defense attorney used this term in summation to try to use it to his advantage after it had already been admitted over his objection. Also, I think a reasonable strategic choice. And so as in Williams, where the limiting instruction wasn't given for out of concern that it would underscore the prejudice more than no limiting instruction, the same is true here, and it should be reviewed under harmless versus plain error standard. And then I just want to sum up by emphasizing that
With respect to the Organized Crime Bureau, you're here on behalf of the public defender today, of course, and you're arguing in a particular case. Are you suggesting that this court could rule in your favor and say, cannot use Organized Crime Bureau as a designation in this case, and that it would somehow not apply to all other cases as well?
I think the biggest issue with using Organized Crime Bureau in this case was the disconnect between, organized crime and the charges that Mr. Butler was on trial for. I think that if, someone were charged with, gang-related offenses, that maybe the use of or organized crime offenses, that perhaps the use of the term organized crime unit would be okay and would be less prejudicial. Again, if they had said, I work for the narcotics unit, Mr. Butler was on trial for a narcotics crime, I don't think that would have been a problem.
So oftentimes law enforcement officers begin an investigation, not knowing where that investigation will lead and what charges will result. So the fact that the investigation began with the Organized Crime Bureau, but didn't result in gang-related charges, I understand what you're saying about the disconnect, but should it be the case that in every case, the trial courts should look to what unit investigated? Were the charges the same, or did the charges fall specifically within what one would expect the charges to be with that unit? Because there were a large number of people arrested at the same time. He was charged with conspiracy charges, so it does seem a little nebulous how that sort of rule would work.
I think I'm not asking for any sort of bright line rule. I think it's really like a case specific question. And I think it's going to be probably the rare case, as it was in this case, where there's such a prejudicial disconnect between the name of the unit and the crimes that the defendant was on trial for. I don't think that necessarily it would be appropriate for prosecutors to say they work for the major crime unit in a low level possession case. That
is it really going to be that simple? Suppose you have the sex trafficking unit hypothetically investigating a case where they come short of those charges but come up with some others. We're going to require judges to do this analysis in all cases of that sort?
I think it would be pretty clear, cases where there is such a strong disconnect such that it could really prejudice the jury. Again, I don't think this is going to typically be the case. And I don't think it would always amount to reversible error. I think that in this case, really the disconnect and then combined with all of the other improper testimony and comments in opening statement about the wire, everything really built off of each other, and the organized crime unit was just kind of part of that larger problem.
And you're not
but
asking for a holding that it would be plain error such that a court would have to address it sua sponte. You're just saying in the context of this case where it was objected to and that objection was overruled, that was error.
Yes, and I think that by this court, I would ask this court to offer some guidance that the disconnect in this case was problematic, and that might put trial attorneys and judges on alert that if there's a similar disconnect that could be prejudicial, there might be an easy way for officers in that case to testify about the broader office that they work for without giving a potentially prejudicial description of the unit that they work for.
And the idea would be that these could be motions in limine before a trial to ask that these be taken care of in specific circumstances, not necessarily a per se ruling from the court on all cases.
That's correct, Your Honor.
So in some cases, an officer is going to be able to introduce what unit they work for. But in other cases, based on this value judgment, the judge is going to have to preclude the officer from introducing what unit they work for because of this disconnect standard that you think that we should be putting forward on this case.
That's correct, Your Honor. I think that if this court were to find that it was problematic, the disconnect between the name of the unit and the charged crimes, and that prejudiced the defendant here, that would then put, I think, defense attorneys on alert that they could move in limine to preclude officers from testifying about the units that they work for in similar cases where there's a disconnect between the unit and the charged crimes, and the name of the unit could be prejudicial.
Please go ahead.
If Your Honors have no further questions on that, I just wanted to make one last comment about extra evidentiary references and comparisons generally. These comparisons are never appropriate, almost never appropriate, as the risk of prejudice is just too high. But I would ask this court to really emphasize, in State versus Williams, this court said that prosecutors should walk a fine line when making extra evidentiary comparisons between the defendant and someone the jury might associate with violence and guilt. I think maybe a fine line wasn't the strong enough wording. I think extreme caution would be a more proper guidance to prosecutors in terms of how they should be thinking about using these extra evidentiary comparisons. Thank you, Your
counsel.
Honors.
We'll take the matter under advisement.
All right, we know the decision. We're going to read some of the opinion. Oh, did it pause? Okay. We're going to read some of the opinion. We know that they ultimately end up reversing Butler's conviction. Before we do that, I want to emphasize a little bit from this discussion some of the questions to the state, the attorney for the state, and I'm sorry I left the banner up the whole time. The idea that there was a motion in limine. The state could have prepped these law enforcement witnesses. There was more than one who continued to use the term search warrant rather than lawful search. You could have prepped your witness. That's like your job to do when you call witnesses. It reminded me of Detective Dennis over in the YSL trial. And the sound was cutting out in these few days of the YSL trial. Whenever they put an exhibit on screen, the audio from the court wouldn't come through. But this is what happened. Shout out to Dolly in the corner over here. Detective Dennis was called back to the stand. He was on the stand several times. This time around, they brought him back because they wanted to show a bunch of Magic City surveillance footage to talk about some fights and beef between Martinez Arnold Duke and also a possession charge that was tied to Yak, some driving incident where Duke and Yak were both in the cars. And the state ends up asking Detective Dennis about this exhibit where Yak is standing on, I believe, YFN Lucci's car? An op?
Now, looking at State's Exhibit 1 TT, why was...
And then the court loses sound. But Detective Dennis, we're going to find out from the oral arguments, ends up saying that this was right after he got out from being incarcerated. So it's a mention of a defendant's arrest, being incarcerated. That's prejudicial. You're not supposed to do that. So they send the jury out and then they have arguments and Doug Weinstein goes bananas. When it's not supposed to be his conclusion to make. Past me on the screen. So this is just going to be the motions again.
Thank you, Your Honor.
Thank you. How many times has this man testified in a trial? How long has he been I know he's a retired investigator. How long has he been an investigator? He knows he is not supposed to say that, Your Honor.
I would find it surprising if he isn't aware that that's not supposed to come out.
So there we go. Yeah, Judge Whitaker ends up as like a sanction for this happening. Dennis is disqualified as a witness. The jury's instructed to strike that portion of his testimony that day that he was called to the stand. And he cannot be called again to testify in this trial. So, it's important to prep your witnesses. It's something you're supposed to do. And particularly when it comes to someone like a law enforcement officer who, in the course of their career, they will testify many, many times at trial. They should know better, right? It's a little bit different than a nervous witness who it's a big case. They've never testified in any case before. They might not know better. And you really have to coach and prep them. A law enforcement officer on the stand, you should know not to comment on, like, oh, let me identify the defendant who's sitting there in shackles right now, currently handcuffed. There's a Texas case that was overturned because a police officer told the jury that the defendant was presently in shackles in the courtroom. Detective Dennis, oh, he just got out from some stint where he was incarcerated for XYZ. You know better. So you're supposed to prep your witnesses. And that's why the justices here seem to ask the follow-up questions like, well, it shouldn't have been mentioned at all. You could have prepped your witnesses. You just need to know better. So, I don't think, was he called again? I don't think he was called again. They called Thorpe back and then got rid of him after he was on the stand for like 40 seconds. And I think Doug and Max objected because they realized the reason Detective Thorpe was being recalled to the stand in the YSL trial for whatever umpteenth time was because the state was going to get into territory that was part of a granted motion in limine that was meant to be excluded. So they approach at the bench, they come back, and they're like, no further questions. And then Thorpe's like, and then just gets off the stand and leaves. So, oh my goodness. Yes, and Factual Lie just shared Cash Money Cass has done a new Whitaker skit. Whitaker has an opponent in her race. You know, she's got to win re-election to stay on as judge. She has an opponent that, I don't know, doesn't seem to me to have much of a, I don't know. I don't think she's running to purposely oppose Whitaker. I think she was running because she said, hey, I want to be a judge. I don't know. But still, it's important if you want to see Judge Whitaker stay on the bench, if you live in I think it's Fulton County in general that you could vote. I don't think you have to live in a certain part of Fulton County. But if you live in Fulton County, consider making a decision to go and vote for the smaller elections there. So, yeah, another one. We could go down throwbacks of like a long laundry list of things that cause mistrial motions in the YSL trial. The frequay from a Slime Life Shorty on the stand that the state knew they were supposed to redact, but they gave the witness, Slime Life Shorty, Winnie Lee, a printout of the exhibit and told him to keep reading this Instagram caption. So he reads the text, but he stops at the hashtags. And Simone Hilton's like, keep going. And he's like, you want me to keep going? So he reads like one of the next hashtags or says what emoji was there. There was like an emoji. And Hilton was like, keep going. And he's like, are you sure? And then it was like, free Quay, because the hashtag said free Quay. So now you have yet another mention in the YSL trial of two different co-defendants, either Quay or Qua. Didn't matter which one, but 2 of the 6 co-defendants, the jury could have gotten their perception from that caption that either of the Quays had prior criminal history, had prior incarceration, and somebody was on Instagram saying free them. So, oh my goodness. Crazy, crazy. Crazy. Let's see. We've got, let me get this opinion up. We're going to get back on the topic of the day. Which one is this? Nope, that's not the opinion. Oh, and this is a stupid window. Let me make it easier to read. I really don't like the way Google Docs displays things. All right, there we go. Because if I don't, I have to like pretend I'm going to print it. Otherwise, viewing it in Google Drive, it like clogs up with all this AI summary stuff. So obviously we have a decision. We've said it several times in the stream, but we're going to read how the justices got to this decision to overturn Gerald Butler's conviction. We read some of the background earlier. We are going to read it again just in case anyone missed it and to make sure the document makes sense. The oral arguments we watched were from October 21st of 2025. This decision came down last week, 2 weeks ago. Justice Noriega writing for a unanimous court. In this appeal, the court considers defendant Gerald W. Butler's challenge to his conviction for controlled dangerous substances on the basis of prejudicial prosecutorial comments and the admission of evidence Butler contends portrayed him as a violent, organized criminal. Cumberland County Prosecutor's Office Organized Crime Bureau, or OCB, launched an investigation in response to a series of shootings in Millville. Butler was not linked to those underlying incidents of violence. He became the subject of the investigation only after surveillance of wiretap lines captured a phone call during which the participants discussed facilitating a firearm purchase. Police obtained a warrant and searched an apartment they had seen Butler entering. They found heroin, cocaine, drug paraphernalia, and 2 revolvers. The leaseholder of the apartment initially attributed one of the revolvers to Butler, but later recanted. Butler was arrested. Before trial, defendant moved to sanitize references to search warrants. The court instructed the state to use the phrase lawful search and not to mention search warrant. The state agreed. Defendant also sought to preclude references to the OCB. The state offered to craft a limiting instruction, which Butler considered but never pursued. During opening statements, the prosecutor made multiple references to The Wire, a television show widely known for its portrayal of organized crime. You know what they're not including here? They're not including that The Wire is widely known for its one season where it talked about bad cops, prosecutor, cop misconduct. Defendant's immediate objection was overruled. Throughout the trial, the state's witnesses, many of whom identified themselves as members of the OCB, made references to gun violence, weapons trafficking, and organized criminal activity. Despite defense objections, the state questioned witnesses about the search itself, resulting in repeated references to the search warrant. Butler was acquitted of weapons offenses, but convicted of the drug charges. The appellate division affirmed the defendant's convictions. The court granted Butler's petition for certification. That means, hey, when they asked the Supreme Court, like, hey, we think there's a question of law you guys need to consider. Like, is this prejudicial? They asked them to consider, 1, the state's references to The Wire, testimony elicited by the state that Butler was the subject of a search warrant, and references to the organized crime unit, gun violence, and trafficking in the city of Millville, and 2, whether the cumulative effect of the purported errors deprived Butler of a fair trial. So they took the case, they heard it, and they're going to agree with Ms. Allison's arguments. So they're holding here that none of the individual errors that Butler alleges require that his convictions be overturned, but the accumulation of error in this case deprived him of his constitutional right to a fair trial. So 1, in assessing whether a defendant's constitutional... In assessing whether a defendant's constitutional right to a fair trial has been compromised by improper testimony or argument, the question is whether the challenged conduct had the capacity to prejudice the jury and thereby undermine the fairness of the proceedings. Where multiple errors are alleged, the court considers whether their cumulative effect rendered the proceedings fundamentally unfair. An opening statement must be limited to facts the prosecutor intends to prove by competent evidence. Here, the prosecutor invoked The Wire, a television series widely known for its portrayal of organized crime, violence, intimidation, and murder, thus analogizing the events leading to the Millville investigation to a large-scale violent criminal enterprise. The reference invited jurors to associate defendant with violent criminal conduct. You know, this is also reminding me of another Down Bad Dennis throwback, and Underwood, C.C. Underwood, the other detective. The one that Jay Apt cross-examined with the references to, like, I shot the sheriff. I think he mentioned The Godfather. But this idea that, you know, Dennis talked about reading different hip-hop magazines and watching different movies as part of his background and knowledge of the culture and the stuff that he was investigating. Like, it's reminding me of that. There's a lot of parallels here. Again, with the goal of, in YSL, they were actually alleging this violent criminal enterprise. The references invited jurors to associate the defendant with violent criminal conduct, an association untethered to the evidence that created a risk of distracting the jury from its obligation to assess guilt based solely on the facts presented at trial. The court has previously cautioned against relying on pop culture references at trial. See State v. Williams, the Shining case. The State, which was 2021, we might have to look at that. Maybe the oral arguments are available somewhere. What are the attorneys? What if one of the attorneys' name is Johnny and he was called to make his argument? Oh, that'd be a time. The state may not bolster its case with powerful or inflammatory imagery that supplements the jury's role to evaluate actual proof. Here, however, the mention of the show was isolated. The jury was instructed to base its verdict solely on the evidence before it, and the substantial evidence of Butler's guilt presented at trial makes it unlikely that the outcome turned on this improper analogy. Although unnecessary, the reference by itself did not clearly have the capacity to lead to an unjust result. It does not therefore warrant reversal. So they do make it clear that it had no place in this trial, but they wouldn't be willing to overturn the conviction on that alone. The court next reviews the prosecutor's repeated extra evidentiary references. Police may explain the context and genesis of an investigation where needed. However, such background testimony cannot be used as a disguised means of suggesting a defendant's propensity for a crime or involvement in unrelated criminal conduct. The charged offenses form the prism through which the state must prove its case. You can't go outside of it. By constructing a narrative replete with extra evidentiary references to rampant violence, gun trafficking, and massive conspiracies, the state risked misleading the jury. Although the references were thus improper, other safeguards rendered the risk harmless. The evidence presented against defendant on the charged offenses was substantial. Defense counsel had opportunities to object, and the trial court provided instructions limiting the jury's consideration to the evidence on the specific charges. Next, the prosecutor's repeated elicitation of the search warrant and the testimony that the defendant was its target risked precisely the prejudice that the court identified in State v. Kane. So, quoting from that case, a prosecutor may not repeatedly mention that a search warrant was issued by a judge if doing so creates the likelihood that a jury may draw an impermissible inference of guilt. However, Kane also made clear that reversal is not automatic. Here, the jury acquitted Butler of the gun charge, indicating that, even in the face of repeated improper references, the panel weighed the evidence against Butler and was not improperly swayed. Although the trial court erred in overruling defense objections, and the state should not have repeated the same mistake after agreeing to the contrary, these errors standing alone likely satisfy the harmless error standard. The references to the, and like I did say likely, they likely satisfy. The references to the OCB are fundamentally different from the other contested remarks. Use of code and unit names reflects routine law enforcement practice. Defendant did not pursue a limiting instruction. The court discerns no plain error warranting reversal. And this is the one issue that one of the justices was really like poking and prodding at. Because the idea would be if the court were to find here that, you know, we're making all these mentions of the Organized Crime Bureau when this case is really just about finding a firearm and finding contraband, other contraband, drugs. You keep mentioning organized crime, and then you're mentioning The Wire. If the court were to find, yeah, it's bad individually that you're, as a prosecutor, you keep having these law enforcement officers get on the stand and talk about how they're part of the Organized Crime Bureau and they specialize in investigating organized crimes. And they're here today to talk about what they looked at for this particular defendant. If they were to say that that's prejudicial, it would set a precedent that you can never say the division where someone works again, if it might be providing an inference of guilt on the person who's sitting for trial. So the court did not seem to want to touch this issue. Although no single error alone requires reversal, the court cannot conclude beyond a reasonable doubt that the aggregate effect of these improper references did not deprive Butler of a fair trial. The overall impact of repeated analogies to organized violence, improper emphasis on Butler being the target of a judicially sanctioned search warrant, and rhetorical scaffolding extending beyond the facts of the case was inconsistent with Butler's right to have his guilt or innocence evaluated solely based on admissible evidence. And I want to say that I read this type of finding to be the type of thing where the prosecutor pushed too many buttons and crossed too many lines at trial. It's okay if they cross the line a little bit, but the problem is the prosecutor decided to take an inch and make a yard out of it and just run with it. And that's where we are. So reversed and remanded for a new trial. And again, this was a unanimous opinion. So let's get into some of the key arguments. Let's scroll. Let's see. Okay, and it was Stephen C. Sayer that argued for the state. We know Allison Gifford was for the defendant. Ezra was for the ACLU New Jersey. And we didn't hear an oral argument from Dylan McGuire on behalf of New Jersey's ACTL. But that is linked in that resource doc in the description if you guys want to go check out those briefs in full. So let's see. Let's get some context, some of the tea. What did the jury get to hear about? This appeal arises from defendant Gerald Butler's conviction for controlled dangerous substances following a multi-agency investigation known as Operation That's All, folks, spearheaded by the Cumberland County Prosecutor's Office Organized Crime Bureau. Butler challenges his convictions on the basis of prejudicial prosecutorial comments and the admission of evidence he contends portrayed him as a violent organized criminal, a depiction unsupported by the trial record. Although we do not find any of the individual errors that Butler alleges require his conviction be overturned, we conclude that the accumulation of errors in this case deprived him of his constitutional right to a fair trial. We therefore reverse and remand. The following details of the investigation that led to Butler's arrest, prosecution, and trial are derived from the record of the trial court proceedings. Cumberland County Prosecutor's Office launched Operation That's All, folks, in response to a series of shootings in Millville with the state objective of curbing gun violence and weapons trafficking in the city. So this is what the jury keeps hearing about throughout the trial. Police obtained wiretap authorizations for the phones of 3 suspected individuals believed to be involved in the violence. Butler was not initially among them, nor was he linked to those underlying incidents of violence. Butler became a subject of the investigation only after surveillance of the wiretapped lines captured a phone call during which the participants discussed facilitating a firearm purchase. Police claimed to recognize Butler's voice from an interaction years prior. They also linked his identity to the phone number through a social media search by locating a Facebook account under the name Fast Life Blizzy Blizzy Ho, which featured Butler's images. Based on this information, the state successfully sought a wiretap on Butler's phone and intercepted conversations in which Butler confirmed his identity and mentioned CDS distribution. Subsequent surveillance focused on apartment 16D of the Delsey Gardens apartment complex. Officers observed Butler outside and entering the apartment on 2 occasions. They only saw him in a Nissan Maxima, which was not registered in his name. On September 23rd, 2016, an officer, and they're not saying, we don't find out who it was registered to, maybe it was like a girlfriend's or something. On September 23rd, 2016, an officer conducting surveillance at Delsey Gardens testified that he observed a suspected drug transaction between the occupants of 2 cars, a maroon Pontiac Trans Am and a tan or beige Nissan. The officer could not positively identify the driver of either car, nor did he observe any exchange of drugs or money. So he says that he observed a suspected drug transaction, but did not observe any exchange of drugs or money. The officer also did not see what was in either individual's hands. However, after pulling over the Pontiac, police found Joshua Phillips in possession of crack cocaine and heroin. Phillips later stated to police that he'd purchased the drugs from an individual known as Blaze. At trial, Phillips' in-court identification of Butler as Blaze was at best equivocal. Phillips stated that Butler may or may not have seen him and admitted he was high at the time he made his first identification following his arrest and did not recall whether he was shown only one photo or several. Officers testified at trial that the results of their surveillance, combined with a controlled purchase of CDS from Butler by a confidential informant, provided them with sufficient evidence to obtain a search warrant for apartment 16D. On September 28th, 2016, police executed the warrant. Butler and the apartment's leaseholder, Rafael Gonzalez, were not present. Adam Yurdock and several children were found inside. Police recovered heroin, cocaine, drug paraphernalia, and 2 revolvers, a .22 caliber subsequently claimed by Gonzalez, and a .38 caliber, which was found between couch cushions. Regarding the second weapon, the .38 caliber gun, Gonzalez originally provided a statement in which he attributed the gun to Butler, but at trial, Gonzalez recanted, testifying he'd never seen Butler with the gun, explaining that he was angry with Butler at the time he had made that statement. On the day the search warrant was executed, Butler was arrested while driving the Nissan Maxima with his girlfriend. Yeah, probably her car, Tiffany Parker Alexander. A search incident to arrest revealed $875 in cash on Butler's person, and 3 cell phones identified as belonging to Butler and Parker Alexander, but no CDS or weapons. Data extracted from the cell phones later established that Butler used the nickname Blaze and managed the user profile Fast Life Blizzy Ho. Text messages referenced the police search of apartment 16D, and the location data for one phone placed it at or near the apartment complex at times relevant to the investigation. Additional messages on Parker Alexander's phone included communications with Blaze about shared appointments and confirmed arrangements to meet for a doctor's appointment. Before trial, defendant moved to preclude or sanitize the states. And the reason they're including this is because that you could infer that it's probably Blaze and his girlfriend using the phones at this time, if they're talking about something like a doctor's appointment, which is more personal, and tied to a person that the doctor appointment is for. Before trial, defendant moved to preclude or sanitize the state's references to the warrants issued or executed in the case. Defendant also objected to any potential testimony identifying Butler as the target of a search warrant at apartment 16D. The state agreed and suggested that, under State v. Kane, lawful search or valid search were appropriate phrases to use in front of a jury when referring to searches performed subject to a search warrant. The court instructed the state to use the phrase lawful search and not to mention search warrant. The state agreed and both sides accepted the approach. Defendant also requested that officers be barred from referring to their unit, the Organized Crime Bureau. The state responded by offering to craft a limiting instruction that the jury should not infer anything from the name of the specialized unit. Defense counsel requested time to consider the suggested instruction, but never raised the concern again. Counsel also did not request a limiting instruction. So, at trial, the opening statements. Have a good one, Quality. Have a good one. Happy Friday. Happy Friday. So, at trial, the state's opening statements began with multiple references to the television show The Wire. The prosecutor told the jury, and we heard the one justice read a large portion of this quote out. You heard a little bit from the judge about what this case was about. You heard about drugs, you heard about guns, but it's a little bigger than that, because all those guns and drugs go together. This is also a case about a phone intercept, what's also known as a wire. And there was a few years ago, many years ago now, that show on TV called The Wire. And in that show, there was, in Baltimore, a rash of crime happening within the community. It seemed very organized. People were always at certain locations. They seemed to be following a hierarchy or someone's orders, and they were trying to figure out how guns and drugs were coming into their community. And while they were trying to surveil all these different locations, they used all of the investigative means that they had available to them. They still weren't able to really crack down. But they were eventually able to realize that there was a person they really needed to focus on. The only way to really find out how the guns and drugs were flowing in the community was to get on that person's phone. So they got an intercept known as The Wire. That's similar to this case. Back in August to September in 2016 in the city of Millville, the county prosecutor's office, specifically the Organized Crime Unit, got their own wire. And they did this because there was a rash of violence that was happening throughout Millville and throughout the summer of 2016. And they wanted to know what was the emphasis of that. What was the origin? Where was it coming from? Who was involved? And so much was happening that they finally decided they needed to go get on a wire. So as they narrowed down their investigation, they narrowed it down to 4 individuals. And the names of those individuals are not important to you because none of them are Mr. Butler. But do understand that that's how the investigation began. So they go on each of these individuals' phones, and they're listening. And the officers are picking up gun sales, where to meet, what kinds of guns, where it's coming from. There's also discussions about drugs, how much to sell them for, where to meet in person. And then there's an ellipses here. And then I end with this, because after whatever other argument, she comes back to The Wire. That very much like the show The Wire, sometimes the targets tell on themselves. So as you're listening to all of the other witnesses, and you're going to listen to the calls, you're going to hear the text and also listen to the calls. What is he telling you about what he's doing? Defense counsel raised an objection immediately following the state's opening statement, arguing that the references to pop culture were over the top. We've got a footnote here. Because the transcript of this precise moment includes several entries listed as inaudible, the entirety of the objection and ensuing exchange is not included into the record. It was probably very dramatic, very vocalized and dramatic. The trial court overruled the objection, determining that the comments were not overly prejudicial. Following opening statements, the state's evidence relied heavily on intercepted phone calls and text, digital evidence attributed to Butler, observations of Butler at apartment 16D, and related circumstantial evidence. Both Phillips' identification and Gonzalez's attribution statements were strongly contested and qualified at trial. Both witnesses expressed ambivalence or recanted prior statements connecting Butler directly to drugs or firearms in the apartment. No fingerprints, DNA, or other forensic evidence physically connected Butler to the contraband or the firearms. The state also relied on the testimony of a series of law enforcement witnesses. And this is why it's important that you're giving this gap to fill. You're saying, you're making these references just like the show The Wire. They're always at these places. They're always doing these things. They're all in this together. So that could let the jury say, well, so what? So what if the contraband was recovered from 16D when he wasn't there and his stuff wasn't on it? Oh, well, he's doing this stuff anyway. Just get him for it. The state also relied on the testimony of a series of law enforcement witnesses, each of whom played distinct roles in the investigation. Several were directly employed by the Cumberland County Prosecutor's Office Organized Crime Bureau, while others worked for outside agencies but actively participated in the operation. For example, Sergeant Ryan Breslin, testifying as a member of the OCB, described the overarching purpose of the investigation as follows. Q. And could you explain, so this is a question from the prosecutor, all right? Yeah, I think this is from direct examination. So the question to Breslin was, and could you explain for the jury what the purpose of this investigation was? Breslin says, this investigation was to target individuals that had been involved in violence in the city of Millville, as well as weapons trafficking throughout the county. There's an ellipses. Prosecutor says, so as a result of finding these groups of people, what did you then do? Breslin says, so what do you mean? Prosecutor, okay, so you said you'd found an individual who was selling guns. What did you do to further your investigation? Well, so we attempted to, for this one individual, we attempted to conduct a purchase of a firearm from that individual with an undercover officer. That was in September or late August or early September of 2016. Now back to the opinion. Breslin later clarified for the jury. Question from prosecutor. Sergeant Breslin, going back to the sale of the weapon, that did not involve Mr. Butler? Breslin says, what? Prosecutor. The one that we were just talking about, that did not involve Mr. Butler. This is a separate target. A, correct. Going back, the one that we were just talking about, that's confusing. Defendant objected to the line of testimony regarding the Millville shootings and associated violence on relevance grounds, but the trial court overruled the objection and allowed the testimony to proceed. Specifically, the court permitted the state to elicit information from Sergeant Breslin, not only concerning the shootings in Millville, police efforts to address countywide violence and firearms trafficking, but also about investigative actions, such as the attempted undercover firearm purchase unrelated to Butler himself. Yeah, and you're not really spelling out a name to make the distinction. Throughout their testimony, officers identified themselves as members of the OCB. In direct examination, for example, Breslin stated that his role at the time was with the Organized Crime Bureau, and another officer described the coordination with Millville and violent officers participating in Operation That's All, folks. Officers repeatedly referenced the Organized Crime Bureau, explaining the unit's function as tackling violent crimes and gun trafficking in Cumberland County. The defense's objection to those references were limited to those raised pre-trial. After the trial began, the defense did not object to the consistent references to the Organized Crime Bureau. The state also played for the jury a series of intercepted calls featuring coded language such as dime, brick, and bread. The terms were explained for the jury by the state's expert witness, who testified extensively about street language and narcotics distribution networks. But in those specific calls, there was no explicit discussion of firearms. Moreover, despite defense counsel's objections and acknowledgement that the officers had permission to conduct the search, the state consistently questioned witnesses about the search itself. This approach resulted in law enforcement witnesses repeatedly referencing the term search warrant in their responses on a continuing basis. Throughout this line of questioning, the trial court consistently overruled defense objections. When the state called Phillips to testify, he invoked his Fifth Amendment right on multiple occasions, before ultimately agreeing to answer, after stating he felt guilty about doing so. Phillips testified about purchasing drugs from Blaze, whose actual name he did not know, and identified Butler in court as someone that may or may not have been him. Gonzalez testified he never witnessed defendant with a gun, was unaware of any drugs in the apartment, and allowed Butler to stay at his apartment whenever Butler wanted. The state played a recorded conversation between Gonzalez and the police, in which Gonzalez said he allowed Butler to keep personal items in the kitchen cabinet, where police happened to recover drugs. Yurdak, who was present during the apartment 16D search, also testified at trial. Yurdak reiterated he was unaware that there were guns or drugs in the house. In summation, the prosecution again referred to the scope and nature of the investigation. So this is important because this is a guy who was present when the stuff was recovered, and you need to tell the jury that they weren't his. So to do that, you have the guy tell the jury himself in court under oath, where he might not want to incriminate himself. He's like, I didn't know anything was in there. So take me out of the equation by process of the elimination so we can narrow it down to the one guy. In summation, the prosecution again referred to the scope and nature of the investigation, emphasizing to the jury. You learned that there was a huge wide-scale operation known as That's All, Folks, and you also know that Mr. Butler was not the initial target of that investigation. He kind of came up just out of the blue, and it was the first session you listened to this morning, and that drew their attention, because it's going to be up to you to determine what that call was about in the context of the overall investigation, which you knew it was about gun violence in the city of Millville. Defendant did not object at this time. The jury acquitted Butler of the weapons offenses and convicted him solely of the offenses relating to the contraband. Second and third degree conspiracy, distribution, and possession. All firearm-related counts were either resolved by a not guilty verdict or dismissed. On appeal, Butler raised several arguments. Relevant here, he contended, we know the arguments here. Let's see. The appellate division, they said that the wire statements were not intended to inflame the jurors or divert them from the evidence, but to reasonably introduce them to the concept of a wiretap, which was at the core of the state's case. Court found no other errors, in that the state used the television series as an analogy to explain that sometimes the targets tell on themselves, and that in reading defendant's intercepted texts and listening to his calls, they should focus on what Butler is telling you about what he's doing. The appellate court, not the Supreme Court here, the state Supreme Court, also noted that the state did not reference the wire again in closing, and regardless, Butler's counsel did not object to the summation. Accordingly, the court applied plain error review. Although it found that the portion of the summation relating to gun violence was unnecessary and improperly suggestive, it held that this did not satisfy the high bar of plain error. Turning to the testimony implying Butler's involvement in shootings and other violent crimes, the appellate division again emphasized that Butler's counsel failed to object. The court acknowledged the improper nature of the testimony, but found that it more broadly described only the impetus for the investigation that led to Butler's arrest. Further, the court reasoned that the state neither asserted nor suggested Butler's participation in weapons trafficking, and underscored that the jury acquitted him of the gun charge. The court, and these are all things the state Supreme Court still agrees with this. Like, you know, the jury, they used discernment. They exercised discernment here. The court concluded that this testimony was also, quote, not clearly capable of producing an unjust result amounting to plain error. Regarding the repeated references to the search warrants and related language, the appellate division observed that if objections to the testimony had been made, the trial court likely would have sustained them. However, because Butler's counsel failed to object and the references were brief, the appellate court determined that arguments against these comments, either alone or in combination, were insufficient to produce an unjust result. This court granted Butler's petition for certification. This is now we're talking about the state Supreme Court, limited to consideration of the state's reference to the wire, testimony elicited by the state that Butler was the subject of a search warrant, and references to the organized crime unit, gun violence, and trafficking in the city of Millville, and the cumulative error effect. We also granted the applications of the Association of Criminal Defense Lawyers of New Jersey, or ACTL, and the American Civil Liberties Union of New Jersey, so the ACLU New Jersey Division, to participate as amici. Butler contends that his conviction should be overturned because the state, instead of limiting itself to the evidence properly before the jury, relied on references and witness testimony that undermined his right to a fair trial. So specifically, he points to the comparisons to The Wire and the show's violent plot, as well as police testimony that the investigations involved weapons and violence, which he maintains were irrelevant, improper, and prejudicial. Butler further contends that references to the warrants, particularly the statements that the Apartment 16D search warrant targeted him, were prejudicial because they improperly suggested the existence of evidence not before the jury that pointed to his guilt. To Butler, the use of the unit name Organized Crime Bureau was improperly and unfairly prejudicial, and the cumulative effect of these errors unfairly prejudiced the jury and deprived him of a fair trial. In response, the state asked this court to uphold Butler's convictions, arguing that the alleged errors are not prejudicial either individually or cumulatively. The state maintains that the references to the wire were used only to introduce the concept and purpose of a wiretap and did not compare Butler to the violent aspects of or characters in the show. The references to the Organized Crime Bureau and Operation That's All Folks were relevant, according to the state, because they explain the context of the case. The state also asserts that references to Butler as the target of the search warrant were merely explanatory and not improper or suggestive of undisclosed evidence. In support of Butler, the actal argues that the state's reference to the wire were intended to draw a direct comparison between the criminality and drug distribution in Millville and the violence and lawlessness portrayed consistently in episodes of the television show. The actal also echoes Butler's claims regarding improper testimony. The ACLU contends that the state's opening statement should be held to the heightened standards applicable to prosecutors in the criminal justice system. And this is the argument we heard Attorney Ezra argue, Ezra Rosenberg. Notably, the ACLU cites research indicating that up to 90% of jurors reach their verdict during or immediately following opening statements. The ACLU asserts that if the state sought to explain the context of the case and the mechanics of a wiretap, it was unnecessary to rely on popular culture and fictitious references with the inherent risk of improper inferences, especially in the face of simple and self-evident concepts. Yeah, like, it's explaining, like, do you really need a TV show to tell you what a wiretap is? The principal issue before us is whether a series of challenged statements and references made by the state during trial deprive Butler of his right to a fair trial. Specifically, Butler challenges references to the television show The Wire, mentions of gun violence and gun trafficking, all of this stuff. We review each of these claims on their own. We're going to skip some of the case law. Let's see. Talking about what happens when the trial counsel fails to object. For harmless error, the court has to determine that there was a real possibility that the error led to an unjust verdict. And where multiple errors are alleged, we consider whether the cumulative effect rendered the proceedings fundamentally unfair. So that's, the basics of their framework. Let's see. We also consider whether the prosecutor's opening statement and summation included comments that exceeded the permissible bounds and had the capacity to prejudice Butler's right to a fair trial. Our case law sets forth clear parameters governing a prosecutor's opening statement. An opening must be limited to the facts the prosecutor intends in good faith to prove by competent evidence. Its purpose is to outline the state's anticipated proofs, not foreshadow the final argument. Although a prosecutor may describe evidence in reasonable detail, they have a corresponding obligation to present admissible proof supporting those assertions. A prosecutor's failure to do so risks prejudice to the defendant and jeopardizes the fairness of the proceedings. And here's a quote here from, what was this case? Green? I think it's from the Green case. In the end, the court must patrol the boundaries of propriety of a prosecutor's opening statement to ensure that a defendant's right to a fair trial is not compromised. At the outset of the trial here, the prosecutor invoked The Wire, a television series widely known for its portrayal of an organized crime, violence, intimidation, and murder, thus analogizing the events leading to the Millville investigation to a large-scale violent criminal enterprise. Defendant, however, was not identified as a primary participant in the city's outbreak of violence. Although the appellate division characterized the reference as a reasonable means of explaining the wiretap evidence, the analogy bore little relevance to the charges or proofs ultimately presented at trial. Instead, the reference invited jurors to associate defendant with violent criminal conduct, an association untethered to the evidence that created a risk of distracting the jury from its obligation to assess guilt based solely on the facts presented at trial. So, you're referencing fiction, and you're referencing fiction in a way that you're not going to have any evidence that points to those things here in relation to these charges. Referencing the series in the opening minutes of trial effectively framed the jury's understanding of the case and overshadowed the evidence the state intended to present. This court has previously cautioned against relying on pop culture references at trial. In Williams, the Shining case, Extraneous references to works of fiction were found to pose a substantial risk of prejudice by insinuating guilt through association with violent or unsavory characters and themes. And here they reference to a part that notes that referencing a violent and frightening scene from the movie The Shining, so I guess the picture with the axe, in summation was not reasonably related to the evidence presented. Although the reference here was not a direct comparison to a character, its purpose and effect were similar, casting the defendant in the light beyond the evidence. The state may not bolster its case with powerful or inflammatory imagery that supplements the jury's role to evaluate actual proof. In assessing whether the prosecutor's reference to the wire constitute reversible error, we review whether the references sufficiently raise a reasonable doubt as to whether the jury would have reached a different conclusion. We do not condone the prosecutor's use of a television show associated with violence and criminal enterprise to develop its theory. However, we are not persuaded that this fictional comparison, made at the outset of trial and not repeated in closing, by itself, substantially prejudiced Butler's fundamental right to have a jury fairly evaluate the merits of the defense. It cannot be said that the reference to the wire here was identical to that of The Shining and Williams, as argued by Butler and Amici. That is because the mention of the show was isolated. The jury was instructed to base its verdict solely on the evidence before it, and the substantial evidence of Butler's guilt presented at trial makes it unlikely that the outcome turned on this improper analogy. And jurors are expected to follow instructions. But what I think is really interesting, if created by EJF is in the chat. Yesterday, created by EJF was following a case, and she mentioned, oh no, the jurors have questions. They're deliberating. And the jurors asked if they could Google DNA and DNA evidence and how it works. That's a question coming from a juror that was already instructed, I would assume more than once, that they're not to do any outside research. And yet during deliberations, they're asking, can we go do outside research? So this idea, like, it's paradoxical. The idea, well, the jury was instructed, even though there's research presented that, like, more than 80% of jurors are anchored by opening statements alone, and they're instructed not to consider something that isn't evidence, and opening statements are not evidence. It's fine. It's fine. Oh my goodness. They're still deliberating today. Well then, were they sequestered overnight? Do you really think, I meant to ask this yesterday as food for thought. Do you think a jury that sends in a note asking if they can Google DNA and then goes home for the night, do you really believe that not one of those single jurors, I don't know if this is like a 6-panel or 12-panel jury, do you think not one of the 6 or one of the 12, in the least, is gonna go home and go to Google? No one's gonna know. like, oh, you told us no in response to the jury question. You expect that we follow the rules. How do we know? How do we know? And I doubt anyone's going to want to set a precedent that all juries need to be sequestered and they can't use any, like, technology, even while they're not in court, until they're done with the trial. Yeah, so EJF here with the T says, they went home, and this is the second time this case has been tried. The other day, they told the judge they were split at 5-7. Oh my gosh. At least they know, like, kind of the split. But to me, like, that's the problem. Like, we've watched some cases where prosecutors will be like, we only have one shot. I'm sorry we got to take you all the way through this, but we only have one shot. Well, if a jury thinks 5-7, even 5 not guilty, we'll go on the conservative side here, even if only 5 say not guilty, to me, that's enough doubt. That's enough. You shouldn't retry something like that. If it's like 1 and 12, all right, maybe you just had like an unreasonable holdout. All right, okay, I can picture a retrial there. But when you're pretty much half split on guilt, with a jury of peers, and a cold case from 2003. Oh my gosh, it's like the whole bingo card. And yes, we also, Tony here is with the reference to the Jungle Book. We do not need to rewatch that. I've watched Prosecutor Love's opening statements. I think one time was enough. I've probably watched it like 12 times. But yes, at least they did not quote from the Jungle Book. Yeah, and there was no proof in the YSL trial of wolves, anything like that. Anyway, this opinion goes on. The reference was part of a broader structure the prosecutor was building, which relied on evidence that was never introduced nor part of the state's case. Although unnecessary, the reference by itself did not clearly have the capacity to lead to an unjust result. It does not therefore warrant reversal. Next, we consider whether the prosecutor's repeated references to the gun violence and trafficking, so all of the discussion on how did you start off this investigation, created the possibility of affecting the jury's verdict. The risk of prejudice in this case was apparent. Repeated references to gun violence, the broader impact of violence in the Millville community, and organized criminal activity were emphasized, even though those generalizations were tethered neither to Butler nor the charges presented. Throughout the trial, the prosecutor and the state's witnesses invoked imagery of a community suffering from a rash of violence, gun violence, and widespread drug and weapons trafficking, elements not ultimately substantiated by the evidence against Butler. Those references were clearly intended to associate Butler with uncharged violent conduct and broader organized criminal activity. That was plainly improper. Police may explain the context and genesis of an investigation where needed. However, such background testimony cannot be used as a disguised means of suggesting a defendant's propensity for crime or involvement in unrelated conduct. The charged offenses form the prism through which the state must prove its case. By constructing a narrative replete with extra evidentiary references, riddled, to rampant violence, gun trafficking, and massive conspiracies, the state risked misleading the jury. Such a presentation threatened to unjustly associate defendant with uncharged, community-wide wrongdoing, despite the absence of proof of such an association. And it kind of reminds me, like, imagine Juror 409 in the YSL trial. She was an alternate. She was not a deliberating juror, but she did some interviews with Dennis Byron. And based on what she was saying while she was speaking with Dennis, not down bad Dennis Byron, reporter, not the investigator that we watched earlier, different Dennis. She was concerned. One of the things that stood out to her at trial was a picture the state showed where I think it's like Young Thug and maybe a few others, maybe YSL Tick was in the picture too, I forget, and a few others that I don't think were part of the trial. But then there was a young child in the picture, and the young child was holding up, like, making a hand sign of some sort. I don't know which one it was. The state alleged like a million different hand signs were all always gang activity, all always malicious and nefarious, and all always associated with Young Thug and anybody affiliated with YSL. But she expressed that she was concerned that that's not what we should be raising, that we need to get this type of stuff out, which really isn't directly tied to deciding whether or not somebody's guilty as charged of specific offenses. So there's that. There's also the idea in press statements. Imagine if Fani Willis's press statements, when she announced that they're doing the YSL indictment, she gave a figure. I don't remember exactly the figure, but it was like 70 to 80% of the gang violence in Atlanta or Fulton County is tied to YSL and what they're doing. And it was just such a leap of a statistic, whatever it was. And of course, it wasn't actually said during trial, but it was an extrajudicial statement by a prosecutor in anticipation of a prosecution. Giving this idea could taint the jury pool, someone exactly like Juror 409 who is receptive to this sort of messaging, that not only do we want to set an example, but these charges here would reduce, if we get these people off the street, it would reduce the gang violence by 80% in our community. Just wild, wild, wild. Yeah, like, it was like something more like that, Nick. Like, that the baby was being trained from birth. Like when a goose is imprinted on its mother, or like a duck can imprint on whoever it thinks is its mom. And that's just how it goes. So, hey Dee Dee, good to see you. The only proof of a snake was love. The green amphibious emoji. Okay, so back to Butler. The appellate division's finding that plain error applies is belied by the record on this issue. When the state questioned Sergeant Breslin on how Operation That's All Folks began, defense counsel objected to the answer, which included Breslin's statement that we had received information about several shootings being connected within the city of Millville. A sole objection may preserve the issue for review. Here, defense counsel objected, and that objection was overruled, properly marking the record for an appellate court's review. The prosecutor's closing also included explicit reference to gun violence in the city of Millville, reiterating for the jury that the investigation giving rise to the defendant's case was set against the backdrop of broader violent crime. Specifically, the prosecutor stated, "It's going to be up to you to determine what was that call about in the context of the overall investigation, which you knew it was about gun violence in the city of Millville." This doesn't even make sense as a sentence. Can we read this one more time? It's going to be up to you, but you knew it's about gun violence. Like, how are you telling someone it's still up to them to decide, but you're determining for them that they know what it's about? So it reads, "It's going to be up to you to determine what was that call about in the context of the overall investigation, which you knew it was about gun violence in the city of Millville." This remark, placing the defendant within the context of a wide-scale investigation targeting violent offenses, risked unduly prejudicing the jury by associating him with criminal conduct, namely gun violence, which was not at issue in the trial. The statement is problematic because, although it reminds the members of the jury of their duty as sole judges of the facts by stating it is up to them to decide, it simultaneously diverts their focus from the charged offenses and encourages them to focus on a suggested link to community violence rather than on the facts established at trial. As recognized in the appellate opinion, although the comment was fleeting and not found to constitute plain error, it was, okay. So this is why we were commenting on the attorney for the state, Stephen, calling it a fleeting moment when arguing in front of the New Jersey State Supreme Court. But he's actually pulling words from the appellate decision and using them as part of his vernacular for how he's going to argue to the Supreme Court the appellate court decision should stick. You should affirm their decision. You should not overturn this conviction. So it seems like he was adopting the language of the appellate court. So as recognized in the appellate opinion, although the comment was fleeting and not found to constitute plain error, it was unnecessary and improperly suggested defendant's involvement in wide-scale gun violence, underscoring the importance of limiting prosecutorial comments to avoid unfair prejudice and ensure the defendant's right to a fair trial. Against that backdrop, we review this conduct for harmless error. Here, although the risk of prejudice was substantial, especially given the repetition and the emotive framing, we must consider whether other safeguards or the structure of the proceedings rendered the risk harmless. Notably, the evidence presented against defendant on the charged offenses was substantial. Defense counsel had opportunities to object, and in some instances did so, allowing for judicial intervention, and the trial court provided instructions limiting the jury's consideration to the evidence on the specific charges. Moreover, the jury acquitted the defendant of the weapons offense, giving some indication that it distinguished between generalized allegations and the actual evidence pertaining to Butler. This supports the finding that, despite the improper references, the jury was able to fulfill its role as fact finder with fidelity to the record. However, the presence of repeated unsupported references to community violence and organized criminal activity, matters not proven as to Butler, requires some comment. So I wonder what this argument would have looked, or even at the appellate court level, had he been convicted on all counts. Like, I wonder how that would have been argued. So they say such narrative scaffolding is unnecessary, unsupported by the evidence, and improper as a means to bolster charges. So they're saying, hey, look, we don't think it's harmful here, but the fact that the prosecution was doing this, making all of these repeated unsupported references, we have to comment on it. It's required. We have to make a comment. Such narrative scaffolding is unnecessary, unsupported by the evidence, and improper as a means to bolster charges. I like this phrasing rather than bolstering, like saying that you're like bolstering, you're kind of holding it up. Scaffolding gives me the image of like you're adding things around something to construct construct what otherwise wouldn't be there. So I kind of like that similar way of saying bolstering with a little bit of a different imagery. The prosecutor's duty is to provide the facts fairly, without prejudice or emotional manipulation, and to remain within the bounds set by the evidence and the charges. Ultimately, although such recurring comments are strongly discouraged and risk undermining a trial's fairness, the record does not raise a reasonable doubt as to whether the jury's verdict in this matter was unjustly reached by virtue of this error alone. Wait, is that the standard? Hold on, we're on page 39. Let's go to the beginning. What was the case law? Yeah, okay, that is the standard. So to warrant reversal by this court, an error at trial must be sufficient to raise a reasonable doubt as to whether the error led the jury to a result it otherwise might not have reached. So, because here, yeah, then they switched to the cumulative. We'll get to that. We're almost there. All right, so we turn now to the prosecutor's repeated elicitation of the search warrant for apartment 16D and the testimony that defendant was its target. As a practical matter, prosecutors are not prohibited from referencing search warrants during the presentation of their cases. More importantly, the state is not required to hide the fact that law enforcement acted pursuant to an authorized warrant. It is no secret that jurors generally understand that searches of private homes ordinarily require a warrant, and limited references to a warrant may be necessary to avoid speculation that the police acted unlawfully or arbitrarily. That principle, however, has limits. When the existence of a search warrant is used to establish the forbidden inference that the issuance of a warrant by a judge supports the rendering of a guilty verdict, the jury may be misled. Where the legality of the search is not contested, repeated or emphasized references to the issuance of a search warrant, particularly those highlighting that a judge authorized the search, risk inviting jurors to draw the improper conclusion that a neutral judicial officer has already approved the state's evidence. Creating such an inference impermissibly interferes with the jury's unique fact-finding role. And a little throwback to Marissa Viverito in the YSL trial. A bit differently there, we had a very good cross-examination of Marissa Viverito by Max Shart, who represented Shannon Stillwell, as you all know if you've heard him speak one time. He gets up there and he's like, this is the affidavit you put in front of a judge and you signed as having personal knowledge that this Instagram story that Young Thug Jeffrey Williams posted that said 24 M's, like millions, on an N, the N-words, head, in reference to Lil Uzi Vert, the rapper who just got a $24 million diamond embedded in his forehead. You represented on this affidavit that it was Young Thug taking out a bounty for an op, putting money on someone's head to get them killed. Murder for hire. She eventually concedes that yes, that was what she represented. And then Shart goes so far to ask her if she would do it again, and she says she would do it again. So, in that case, Shart had the opportunity to question the individual that was making the representations that the judge accepted and relied on. So, the judge relied on what he thought was a good faith basis, and you're able to challenge that in front of the jury. You can't just call the judge in and be like, Judge, why did you approve this search warrant? If Marissa Viverito wasn't such a snot nose on the stand, doubling down and planting her feet so deeply into the dirt that she couldn't just say, hey, you know, I might have misunderstood that because of the context of all this other stuff, but everything else I put in that warrant was sufficient. And we don't know. We can't run through a scenario where we had to do a round two, go through the judge with that piece of information removed to see if the judge would approve it. Right? So a bit of a different angle than relying on the judge having ordained the search warrant and also not challenging the detectives on what they use in that search warrant to get the judge to sign off on it. So yeah, here they're saying particularly those who highlighted that the judge authorized the search, and creating such an inference impermissibly interferes with the jury's unique fact-finding role. In State v. Kane, this court reaffirmed Marshall but declined to impose a categorical bar on the mention of search warrants. The court observed that officers can reference they had a search warrant to show they had lawful authority to conduct a search and to dispel any notion that police acted arbitrarily. But the court emphasized that repeated statements that a judge issued a search warrant for a defendant's home when lawfulness of the search is not at issue. So we're not saying it's like it was unlawful and we should suppress this evidence. It's not an issue here. We're just saying like, hey, you found that stuff, but it's not my client's. Like my client wasn't there. When lawfulness of the search is not at issue, may lead the jury to draw the forbidden inference that the issuance of a warrant by a judge supports the rendering of a guilty verdict. So, targeted search warrant, we heard this guy in a wiretap, we want to go to this apartment 16D because we're looking for this guy specifically to find stuff that belongs to him. That's why they're arguing it's problematic here for the purpose of this case. The prosecution may neither use a search warrant to suggest judicial endorsement of guilt, nor introduce such evidence without legitimate purpose. The critical issue for consideration is not the number of references, but their purpose and effect. References that go beyond what is necessary to inform the jury that the officers were acting with lawful authority, and instead focus on the jury's attention on the, quote, constant drumbeat that a judicial officer issued a warrant to search, carry little probative value and should be excluded. Here, the state repeatedly referred to Butler as the target of the search warrant over defendants' repeated objections. I like this too, the constant drumbeat. We're going to repeat something over and over. Like, to the point where, was this one search warrant, or going back to this broader visualization from the comparison to the show The Wire and part of the prosecution's opening statements that they're always at the same places, they're always doing this. Well, if we keep mentioning a search warrant and we're vague about how we're doing it, the juror might get the wrong impression that multiple search warrants, different search warrants, were approved. And that they're finding all of this stuff on this guy all the time. So, constant drumbeat. So here the state repeatedly referred to Butler as the target of the search warrant over defendants' repeated objections. And despite having been instructed during a pretrial hearing and having explicitly agreed to abide by governing case law and limit the mention to lawful searches only, the testimony risked precisely the prejudice this court identified in Kane. A prosecutor may not repeatedly mention that a search warrant was issued by a judge if doing so creates the likelihood that a jury may draw an impermissible inference of guilt. However, Kane also made clear that reversal is not automatic. Errors will be considered prejudicial, subject to harmless or plain error analysis. So what are we going to say here? They're going to say, well, even assuming that the defense objection was sufficient and that harmless error is the appropriate standard, the explicit repeated references to the warrants, although improper, would not require reversal unless they were sufficient to raise a reasonable doubt as to whether the error led the jury to result it might not otherwise have reached. Where here the state presented evidence through its wiretap, coded communications, testimony about drugs recovered, and digital forensics, all tying Butler to the alleged activity. Notably, the jury's acquittal of Butler on the weapons charges, despite references to the search warrants targeting Butler, suggests that the jury distinguished Butler's status as a subject of the search warrant from his personal culpability regarding the weapons found at the apartment. The verdict indicates that the jurors did not conflate the state's assertion that defendant was the target of the search warrant for the apartment with actual guilt as to the charged firearms offense. It cannot be overlooked, however, that the state expressly agreed to limit its language to lawful search and then violated that stipulation repeatedly eliciting improper references in direct examination of its own witnesses, many of whom were professionals trained to satisfy in court and fully capable of understanding the significance of legal stipulations and restrictions. As a result, the defense's objections, grounded in this court's precedent, should have been sustained, and the state should have abided by its pretrial agreement. The jury acquitted Butler of the gun charge, indicating that, even in the face of repeated improper comments and references, the panel weighed the evidence against Butler and was not improperly swayed by its repeated yet impermissible use. Although the trial court erred in overruling, and One thing I would say here is, like, you really don't know. Maybe they said, hey, let's say yes to the drugs and no to the guns because maybe the drug possession's more serious and we're going to do a compromise verdict. Maybe the jury reached the conclusion just to split the baby. I get that this is one inference, but they're leaning on it pretty heavily. Although the trial court erred in overruling defense objections and the state should not have repeated the same mistakes after agreeing to the contrary, these errors standing alone likely satisfy the harmless error standard. That said, not all references, and this use of likely satisfy just shows to me if this cumulative error argument wasn't there, maybe they would have taken issue with one of these. But they're not going to weigh in on it because they know that they're going to be able to rely on the cumulative error doctrine, and they don't need to set some dangerous precedent for a future case on any of these other individual prongs. That said, not all references are equally prejudicial. The references to the OCB are fundamentally different from other contested remarks. Law enforcement routinely, so they're going to specify, and I bet this one justice really wanted to make this clear. Like, hey, we really don't think that these references to the OCB are a big deal. The other things were bigger deals. Law enforcement routinely uses distinct unit and operation names for a variety of legitimate reasons, including operational security, internal organization, team morale, and mnemonic convenience. Such code names are often conceived long before any particular defendant is identified or tried. They reflect routine law enforcement practice rather than an implicit characterization of any individual defendant. We see no principled basis to generally prohibit use of such unit names at trial. Importantly, defense counsel was expressly given the opportunity to request a limiting instruction to address any legitimate concerns over possible prejudice stemming from the unit's name. In this case, the parties recognized the issue before trial. They mutually agreed that should the defense seek a limiting instruction, the state would be given the chance to propose one, and the trial court would consider it as part of preparing the final jury charge. Nonetheless, defense counsel reserved the right to consider, but ultimately did not pursue that instruction at any point before or during trial. Any potential prejudice was meaningfully addressed by the parties during the trial process. The defense's strategic decision, so we didn't have an ineffective assistance of counsel issue raised here, but even so, they're saying here it was a strategic decision by trial counsel to not request a limiting instruction after it was offered, cannot now form the basis to argue that the reference to OCB was an error, let alone plain error. Going forward, how parties choose to address this sort of isolated concern can easily be resolved in pretrial conferences, as was done here. So we already have pathways. You can make the choice. Here they did not choose to make the choice. But on this record, where the procedural safeguard was presented and unused, the court discerns no plain error warranting reversal. So they got that part out. They're like, hey, like, we really want to make it clear we're not trying to impede on a prosecutor's name to say an organizational name. A prosecutor's ability to say an organizational name. Now they're moving on. Now we address whether these errors taken together justify overturning the jury's verdict. An appellate court may reverse a trial court's judgment if the cumulative effect of a series of errors is so great as to deprive a defendant of a fair trial. We do not focus our analysis on the number of mistakes, but rather consider whether the errors together amount to an injustice. So they're saying here, it's not like if you only have 3 errors, you can't get a reversal, but as soon as you have 4, you get a reversal. They're saying, no, it's the effect that we weigh, not the sheer number. If the combined effect of multiple errors deprives a party of a fair trial, an appellate court should order a new trial. Where an error involves a constitutional right, reversal is warranted unless we can conclude beyond a reasonable doubt that the cumulative errors were harmless. So, now this is important case law because this is where I was getting the burden confused. This is where we heard the state Supreme Court's going to say, when it comes to the accumulation of errors, we cannot conclude beyond a reasonable doubt that the cumulative impact of these errors were harmless. And here, at least one of these errors involves a constitutional right. So they're going to find that these two things are met, and that's why they're ultimately going to reverse. In this case, references to the television show The Wire, unsolicited framing of the investigation as a response to large-scale gun violence, and organized crime in Millville, risked inviting the jury to associate Butler with criminal conduct and violence far beyond the evidence adduced at trial. That problem was compounded by repeated mention of Butler as the target of the judicially authorized search warrant for the apartment, which invited jurors to infer the court found the evidence against him credible. It is true that each of those instances, viewed in isolation, may not have altered the jury's verdict. The reference to The Wire was limited to opening statement and not repeated in summation. The jury was instructed to decide the case solely on the trial evidence. Improper reliance on background violence and weapons trafficking, unsupported by specific evidence against Butler, was paired with direct proof on the charged narcotics offense. Mentions of warrants and target status, though contrary to the state's agreement and judicial admonition, did not result in a conviction on the weapons counts, suggesting the jury was sensitive to distinctions among the evidence. However, the cumulative effect of these repeated references must be assessed not by their frequency alone, but by their compounded impact on the jury's impartiality. When a defendant is repeatedly, even if only implicitly, portrayed as connected to violent crime and subjected to judicial scrutiny, limiting jury instructions and acquittal on certain counts cannot entirely neutralize the potential for bias. The risk is not limited to the counts for which the defendant was acquitted. Rather, it extends to all decisions the jury was required to make, including those related to the charged offenses for which Butler was convicted. The defense raised objections to these references and even entered an explicit pretrial agreement as to the proper terminology for warrants. The state's repeated deviation from those agreed limitations, whether intentional or not, compounded the confusion and prejudice. Although the jury resolved the weapons offenses in defendant's favor, the narrative structure assembled by the prosecution of large-scale weapons trafficking, drug trafficking, and violent crime still risked coloring the jurors' attitudes and deliberations regarding the remaining accusations. Thus, although we find no single error alone requires reversal, we cannot conclude beyond a reasonable doubt that the aggregate effect of these improper references did not deprive Butler of a fair trial. The overall impact of repeated analogies to organized violence, improper emphasis on Butler being the target of a judicially sanctioned search warrant, and rhetorical scaffolding extending beyond the facts of the case was inconsistent with Butler's right to have his guilt or innocence evaluated solely based on admissible evidence. The cumulative effect of these errors cannot be overlooked. The state's framing of the case blurred the lines between facts properly before the jury and emotional undertones of uncharged violence, which created a real risk that the verdict was tainted by improper influence. Butler was entitled to a trial decided exclusively on the relevant facts and evidence, undistorted by extraneous themes and references that had no place in the jury's deliberations. Accordingly, the cumulative effect of the identified errors deprived Butler of his right to a fair trial. The judgment of the appellate division is reversed and a new trial is ordered. So, what'll be interesting, and I want to see which justice this was that wrote this. Let's see. New Jersey Supreme Court panel. It was this guy. Oh. So he asked a bunch of questions. So what's interesting here is for a retrial. Like, hopefully the state would learn from doing all of these coloring outside the lines things and at least simmer it down, right? They're probably going to be like, all right, we can do like one or two, because clearly the court's not going to find it harmless if we just step over the line once or twice. But we've got to make sure we don't do it too much, that someone could successfully argue a cumulative error issue and we get overturned again, right? So hopefully they learn their lesson, at least in part. I don't think they'll learn it in full. I don't think they'll take the critiques on the individual enumerations of error to heart. But if they have a retrial and Butler was acquitted, there are no charges relating to firearms anymore. Does that then get more difficult? Like, the state's still going to be able to introduce the wiretap that shows Butler was mentioned in a call about a possible firearm sale, but that would only be introduced to show how the investigation eventually led to Butler. And hopefully they learn their lesson and don't just keep making these repeated references to search warrant, search warrant, search warrant. Imagine trying this case again, though, and you don't have that count there. Because I'm sure some of the mentions, not just because of the critique here from the Supreme Court, but also because it's no longer a relevant charge. It's only probative if it's helping us understand the course of the investigation. Will look like a very different trial. Will look like a very different trial. And again, the drugs that he's charged with, it's the drugs that were found in this apartment 16D when he wasn't there. It's not drugs that were recovered while he was like doing an exchange somewhere, where the drugs are actually on his person or somebody sees an exchange, and the best we have is the guy who thinks he saw Blaze. And I think that's going to be what the case centers on, is that one witness. That one witness, and then the guy at the residence who was there with the kids, who was like, yeah, I let him keep stuff in the kitchen cabinet sometimes, which is presumably where, when they searched, they recovered the contraband. And then the other guy was like, I was at the house, but those drugs weren't mine. I didn't know there were even drugs in the cabinet. That's going to be their case. That's going to be their case against this guy. It should be like a half-day trial, really, if we don't introduce all this other stuff. So, yeah, maybe we'll reference a different show next time. Oh, my goodness. Also, let me see. Let's see. All right, New York versus Edward Hawley in Orange County. Oh, I'm going to look that up. That's sort of old stomping grounds a little bit. Used to go out there for a lot of music shows. Let's see, I'm going to look that one up. So New York v. Edward Hawley is the case with this jury question happening. The jurors are deliberating right now. Yesterday they asked if they could go Google DNA evidence. So, oh man. Crazy. And also there's the more info on Facebook than Twitter. I actually like finding, I look up cases and like names, anything news related. I try to start with Twitter because I feel like it's like the quickest thing. But sometimes following a case, especially where people are having conversations and might not be, comments on ongoing stuff, you're not always going to spell out Edward Hawley on everything that you comment. So sometimes it's hard to find information because you just can't use a keyword search to find it. Once you find like a group, or like maybe a journalist is in the court and reporting on a specific case, once you find and follow or engage with a post like that on Facebook, I think Facebook's topical affinity for like, hey, you like this post that was talking about this case, here's other people that are talking about it. I think their algorithm, their affinity is very good to place more information, even from people that aren't directly searching out or following. When they talk about the topic, it pops up for you. So I actually think Facebook's a really good place for like local trial watches. So yeah, shout out to Poughkeepsie. I used to go to shows over, I forget, what was the upstairs of the Chance called? The Chance is closed now, right? Right? I think the Chance closed down last I heard. But I don't know, maybe I'm getting confused. But yeah, we used to go out there. There was also what was it? How long ago would this have been? I think it was Lloyd Banks. Was it Lloyd Banks? I don't know if that seems right. Lloyd Banks used to DJ. Why am I saying it's Lloyd Banks? I feel like it's not actually Lloyd Banks. But he used to DJ at some like venue over in Poughkeepsie. So, heck yeah, shout out to the Chance. Lots of memories over there. Nice little venue. And I forget what the upstairs was called. Maybe it didn't have a distinguished name, but they were really supportive of smaller groups too. You could go see smaller acts. Oh, what a throwback. I've got to go. Beautiful area. The Hudson Valley area in New York is just such a beautiful area. So if you ever, like, say, if you're not in the area, but you ever take like you're planning a trip to New York City, Hudson Valley, like take a day trip, do something in the Hudson Valley. Like tons of stuff to do. Tons of stuff to do. Poughkeepsie was an answer on Jeopardy last night. Love it. There's also the Poughkeepsie tapes, right? If you're into the true crime thing, there's the Poughkeepsie tapes story, obviously out of Poughkeepsie. Don't correct me. If you're like, that's actually not out of Poughkeepsie, don't tell me. Don't shatter my world. Hey, Amanda Lives Mom, good to see you. Yeah, something like that. Something like that. That sounds very familiar. See, Mishes, hopefully they bring up The Wire again in the retrial. We'll get back again. We'll get back again to watch the second round of appellate arguments. That guy Nick says, man, Viv sucked. Yeah, we'll keep her. You know, the more people who understand, this is Kathy Ferguson in a bush. This became a meme while we were watching some testimony from TBI agents in the Zachary Adams post-conviction stuff over in Tennessee. Did I say TBI? It's TBI. Hopefully I didn't say GBI. But this all started with this original little goofball image I put together of Marissa Viverito in the bushes. Because during her Daubert hearing, she had 2 Daubert hearings. They're trying to qualify her as a gang expert. She was describing, you know, you got your training and your personal experience and your work experience and how your opinions are informed. And she went on this little diatribe about how her knowledge of the Cleveland gangs in the Atlanta area of Cleveland Avenue came to be because she would do field work hiding out in the bushes of Cleveland Avenue, observing citizens in their, quote, natural habitat. So I put her in the bush. Put her in the bush, and she's become a meme. She's become a meme. She doesn't really like that she's on social media. So, the prosecutors tried to revoke Young Thug's bond, citing that he was making direct threats, but the citations were other people making comments about Marissa Viverito and not Jeffrey Williams himself saying anything. All he did was call her, repost a picture of her, and say she's the biggest liar in the DA's office. Which, that's an opinion, and I think it's a well-founded opinion. So, it's the one who said she would knowingly submit an affidavit after admitting that there was a misrepresentation. She said she would do it again. So, well-founded opinion that she's a big liar. So there we go, you guys. This wraps it up for our, this is cool. We got to head over to New Jersey today. New Jersey, I see a lot of stuff about police misconduct. They do a lot of research, statistics on, incidents that are reported of police misconduct, what they're doing to crack down on it. So that's kind of really the only other thing I can think of that I look at a lot in New Jersey. So it's kind of cool to see a case. Here's a case. Here's the Supreme Court and oral arguments. We got to visit a different state today. I think this weekend, tomorrow, guys, we'll probably be back in Georgia for something. Might do an update on the opinion in a case that we watched Brian Steele argue. They affirmed the conviction. It was not overturned. This was the squatter situation where the guy goes into the property that he inherited and he was trying to fix it up. And one day there's a man sleeping in the bed upstairs, and ultimately the guy walking into the home shoots the squatter and he's convicted. Steele argued that appeal. The conviction's not overturned, but we might go read the opinion. That would take us back to Georgia. Tennessee, there's some stuff going on in Tennessee, and I think also on the chopping block, I want to talk about Sonny's case, which is going to be Alabama. But I don't know. We might go back to Indiana soon. We were talking about Reginald Diller's exoneration. He was recently released. I think that was the last stream before I took a week off to do some work. I think that was like the last stream we got together to do was the Reginald Dillard. He was walking out. He was freed. But there were like 3 other cases that were like associated with the same appellate issues. I think it'd be interesting to look at least one more of those cases. So we might be back in Indiana sometime soon. Who knows? There's a lot we could do. Give Georgia a break for one day. Just one day. We did talk about them a little bit. Only like a reference, right? To, hey, if you want to understand a concept, we can tie it back to YSL trial on day 1 out of whatever, 167 days. Oh, man. Yeah, Delphi would be parallel. Delphi, oh, there's so much. I don't have the time commitment, but I am following along with a lot of other channels there. But yeah. Yeah, YP cops in Jersey are bad. Well, in the mid 80s they were. There's actually a lot. I think they're one of the most proactive on trying to cut down on it. So whether or not that's actually changing anything, and of course any change it's going to have, I feel like you have to let time pass for it to actually, the change needs time to sow its seeds and root down. We might not see much of an impact from the changes, but it really does seem like they're taking their discipline seriously. So, I'm trying to put together, I think the way I'm going to theme like a FOSS marathon would probably be around watching like appellate arguments. And I don't know if I would do it on cases like appeals for cold cases or steel appeals or what. But I think it would just be one long watch marathon there. So, or it could be me if you guys want to do a stream where I read academic papers on, degradation of DNA in anaerobic environments and its impact for forensic analysis for criminal prosecutions. We could do that too. It'll be a lot of me mispronouncing things. It'll be a lot of mispronunciations. So, true crime design, let me get a link. Okay, true. All right, so there is True Crime Designs link in the chat. And actually, I could link right to the playlist. And what I'll do for replay crew is, let's see. I'm picking a random video and I'm going to add it. It says a year ago. So, the creator friends is kind of like what people are doing right now, but this is an exception. That way anyone on replay crew can go to the creator friends playlist and just look for, it's called Richard Allen Framed. That is a video from True Crime Designs channel if you guys want a quick way to find her channel if you're watching on replay. So there we go. I have not watched this whole playlist, but I know her channel. I'm familiar with some of the videos that she's done. But unfortunately, when the trial was happening, as I think a lot of you have heard me mention, I was trying to listen to Andrea Burkhart's recaps and then hop over to Defense Diaries recaps because they were there in person. There were no cameras there for anyone that's not familiar with the case. There were no cameras for the trial. You couldn't just watch a stream. So, Andrea Burkhart, Lawyer Lee, Defense Diaries, a bunch of people all went down there and they were taking notes. And then after being in court all day, they'd come home and do streams recapping what happened for the day. And I was losing. I couldn't keep up with it. So at minimum, I tried to at least watch Andrea's. And if I had time, I would watch Defense Diaries. And certain days, I'd hop over to Lawyer Lee as well. It's a lot. It is a lot. Her note-taking, Andrea Burkhart's note-taking is, there's a lot of reasons Andrea is amazing. But her note-taking is a skill and like a shining star moment all in and of itself. So, yes, and Brian Steele did do an interview. I saw it shared over on X. I'll be honest, guys, I'm so swamped with like cases and stuff that sometimes the interviews that are a bit more casual, even where a case might be mentioned, I just don't have time to watch these longer things. So, what's his channel name though? Right? Isn't his podcast called something specific? Or am I making that up? On YouTube, it's just Killer Micah's channel, but what's his podcast? Conversations? Conversate. Okay. So if you want to look it up as a podcast on a streaming platform, put Conversate with Killer Mike. And then here is his interview with Steele, if you guys want to watch that. Oh, that's just a clip. Yeah. Okay, here's the full thing. 2 hours. And I'm not trying to claim that I'm friends with Killer Mike. That'd be very cool if, I could be like, hey, Killer Mike, let's conversate. But for the sake of convenience, I'm putting him in the creator friends playlist. So that is not implication that he's my personal friend. I'll pretend we're friends. But there we go. There's that, you guys. I'm going to wrap this up. I don't have my time is kind of choppy for the upcoming days, so it's going to be pop in, pop out. Oh, wait, before we leave, I wanted to look at if there was an update in the Scott Spivey. I didn't see a filing before the stream started. Because remember, we're waiting on the judge to issue a decision on one of the co-defendants, Mr. Williams, who was the passenger in the car, if he will have immunity from the civil action under Stand Your Ground. And that decision is supposed to be due today. Maybe that wasn't binding, though. Maybe that's just when the judge wanted to turn it in. Yeah, I agree. And I like that, Killer Mike speaks on a lot of issues. And more importantly, I think I really like, it, as his podcast is aptly named, he really likes to have conversations with people. And sometimes when people speak out on issues, especially if the genre, sometimes it's politics that he speaks out on. I think people don't like to have conversations with people that don't exactly align with them 100%. But I think the easiest way to make a change and come to an agreement is to, identify with people that you don't see eye to eye with on every single issue and say, hey, this issue is important and we all think it sucks, so we should change this. So it's big respect for Killer Mike and, what I've seen him do over the years. Let's see. Okay, I don't see an update. It's still showing that the last thing was, and we'll read this. Once the decision comes down, we'll also read, like, the written brief that, I still have Viverito on the screen. She's still up here in the corner. We'll also look at the brief they supported. That's the theatrical attorney with the stick, L. Morgan Martin, or L. Martin Morgan. We saw him do his bap, 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 bap closing argument. To argue that his client, Kenneth Williams, should have immunity from prosecution here, from the civil action. We can also read what they submitted in writing when we get the judge's decision. So we'll read both of those things. If that comes down today, I'll probably pop live again. So put your notification bell on for that. That should be pretty short, just to read through the two things. But other than that, yeah, it's going to be a hodgepodge. I should really put together a calendar and just go with it, like 2 hours a day until we catch up on some of the backlog of cases I want to talk about. So with that being said, you guys, I will be live again. I just don't know how soon or when, but just hit that bell. You can unhit the bell like a week from now, but hit the bell for this week so you get notified when I'm going live. Make sure you select all notifications. Otherwise, it'll just pick and choose and probably not give you any notifications. And then you could switch it back after a week to whatever the other option is instead of getting all notifications. So thanks for hanging out with this one, you guys. I really like looking at appellate arguments. I'm glad you guys too. It was cool to see a reference to The Wire, which is obviously why this case was particularly on my radar. But you guys all have a great Friday. Hope to see you guys somewhere else out in one of these chats. Nick's panel is 5 or 6 p.m. coming up in a few hours Eastern time today. I have sort of been catching bits of the Corey Richins trial. Yes, Sharon Moore, he had a hearing today. It might still be going on, right? I know he had a hearing today. I don't know if it's still going. That's happening. Next week, you guys, I think we have... What do we have on the calendar next week? Alicia Andrews' status hearing on the 10th. I'm waiting to see if she files a supplemental brief of her arguments for reconsideration for judgment notwithstanding the verdict. So if that gets filed, we'll watch the hearing and we'll read that on the same day. That's Tuesday. And nothing else. The week after, we have a Clenny status hearing. And I think we have a Antonio Brown Stand Your Ground hearing the week after that as well. So a couple things coming up that we'll watch live. So see you guys soon. Let me kick myself off here. Hope everyone has a great Friday. Thanks so much for tuning in.